This is a circular. This is a circular. Not an order. Issued by the undersecretary. Not even an order in the name by order in the name of the government. It's a short order, may be permitted to read the circular. Education Department is providing first and second PU education in the state. PUC education is the main stage in the student's life. In accordance with the government and department direction, and in order to utilize the grants, kindly mark it.
Yes. This constitute the Development Council.
Yeah. In accordance with the government and department direction, and in order to utilize the grants, kindly mark it. First purpose is to utilize the grants, as well as in maintaining academic standards. Second one, and third, and development of infrastructure. We are hereby directed to form a college development committee and follow the guidelines. Sir, this is not a committee constituted for purposes of dealing with the students' welfare, students' discipline, or exercise any kind of police powers over the
maintaining academic standards.
Academic standard is for the academic standards only, not with reference to the students. And more important,
whether the uniform cannot be prescribed by the colleges to maintain the academic standards.
With great respect, it has no connection whatsoever with the academic standards. Academic standards deal with student-teacher ratio. Academic standards deal with the curriculum, the syllabus, and the way the classes are conducted, etc., etc. It cannot be, by any stretch of imagination, connected with prescribing or exercising police powers over the students. Like
why it can't be read that it may, for the maintaining uniformity, discipline, the uniforms are necessary, and in order to maintain academic standards.
Sir, that I have pointed out, that field is already occupied. It is covered by the Act. Section 7 covers all these aspects. Now can such a body be entrusted with police powers over the students? Is the short question. Now kindly note the composition.
What is that police power, sir?
Police power is to discipline the students.
Uniforms are prescribed in Sanskrit Pathshala. It is not a police power. They are if it is prescribed to police people, military people, defense, I can understand. In educational institutions, what is prescribed cannot be said to be in exercise of police power.
Supervision and control over the students is the police power that is contemplated. Whether a student can be restored, whether the student can be brought under any particular rule.
Any judicial opinion is contrary to what you are saying.
Yeah.
Judicial opinion is contrary to what you are saying. It's never treated as police power in any civilized jurisdictions. Except parental power. Courts have treated is parentis potestas. Never police power. If you cite one single decision, I'll be extremely happy. I will confess that I am wrong. One single authority.
No. The power to discipline students is the power I have referred to as police power. Now that is not what I am saying is this order does not entrust that work, that responsibility, that function to this committee. Be that as it may, kindly look at the composition of the committee.
You say that this College Development Committee has no power to prescribe uniform.
Yeah, no power to prescribe uniform. Secondly,
yes,
this is a committee to which no power can be delegated under section 143. Because this is not an authority under the Act, much less is it an authority or an officer subordinate to the government. I asked this question myself. Can MLA be considered as subordinate to the government? If this committee is considered as a subordinate to the government, MLA becomes a subordinate to the government. Sir, the other day court was pleased to ask a very pertinent question. What is wrong if the MLA is appointed? If I may say so with respect. Under our constitution, it is the representatives of the people, either MLAs or members of the parliament, who hold the government accountable. The hallmark of Indian democracy is accountability of the government through our elected representatives. Here is an MLA who is endowed with administrative powers. To whom is he accountable? This takes away that basic quality of Indian democracy, namely accountability of the government. Now MLA takes over the administration. Apart from the fact that the doctrine of separation of powers ensures that there is no mixing up of the two functions, namely the legislative function and the executive function. So, when MLA or member of the parliament entrusted with any power, either under the statute this is unknown, sir. This entrustment of this. Court was also pleased to ask whether there is no other committee constituted under the chairmanship of the MLAs. I go down to that question. Sir, I have my colleague who is there before the court. In the year 2015, on 16/11/2015, the government constituted a committee under the chairmanship of the local MLA for preparing the list of beneficiaries for distributing house sites and houses under the free housing scheme, like Rajiv Gandhi, Jagjivan Rao, Atal Bihari Vajpayee, B.R. Ambedkar Niwas Yojana. These are all the schemes under which. Kindly see for a minute. I passed on the document.
Was it struck down by some court?
Sir, I myself argued that
Therefore,
the order is stayed. If I may say so with respect, this order is stayed in WP number 6015 of 2017. WP 6015 of 2017. By an order dated by an order dated 14th February 2017, this order has been stayed. Thereafterwards, the government moved for vacating the interim order. That was also considered. And without vacating, modifying the order, the stay was continued. At the same time, the scheme was permitted to be implemented without reference to this. That is the order dated 6/2000. So this is the legal position when another committee was constituted to the MLA. Sir, everything is wrong to give the MLA administrative powers. That will be a death blow to Indian democracy, because MLA should be fearless on the floor of the house to hold the government accountable. He becomes accountable for the exercise of his powers. Kindly look at the powers given. Handling the grants, financial powers, building the infrastructure. That is the major source of corruption in every department. And more importantly, I request the court to kindly take judicial note of the fact that MLA, whoever he may be, he will be representing a political party, a political ideology. Sir, can you entrust this welfare of the students to a political party or a political ideology? With all humility at my command, I very respectfully submit that constitution of a committee of this nature spells a death blow to Indian democracy, doctrine of separation of powers, and the doctrine of accountability of the government. I therefore very respectfully submit that the order delegating this power has to be ignored because it is not statutory in character. And don't allow this committee to handle the welfare of the students, exercise power, disciplinary power against them, check them out of the classrooms on one pretext or the other. Sir, the other thing I want to stress upon is, I have another report, this thing, Honorable Chief Justice may be very familiar. In South India, we are very fond of religious symbols. Yes. Everybody goes to any place, particularly a public place. Even our teachers used to come with religious symbols exhibited either on their forehead or on their, they used to wear caps those days. And in South India, the extent to which this symbol, religious symbol, Honorable Mr. Justice Dikshit is very familiar with this. Sir, there was a temple elephant. The question was, what type of religious symbol should be exhibited on the forehead of the temple elephant? One version said it should be Tengalai. Tengalai is one form of. The other said it should be Vadagalai. Sir, the issue is fought for nearly 250 years. Matter went up to the Privy Council. By the time the final decision came, the elephant was dead. And the verdict came, 6 months you put Vadagalai and another 6 months you put Tengalai. Sir,
that should not happen in this case. Professor, that should not happen in this case.
I very respectfully agree. That should not happen. It has to be nipped in the bud. I agree. It has to be nipped in the bud. Sir, 250 years this issue was fought. The great Parasaran argued the last case, if I remember. And the unsuccessful party, what it did after the decreed namam was painted on the forehead, he went and put a head cover with a different namam. Then they were threatened with arrest and the decree was enforced. In fact, Mr. Parasaran represented that dismissed class. Why I am saying this is, now kindly come to a research paper I have placed before you, just by way of information. Here. My learned colleague will give the copy of the research paper. There was some problem with the pagination, so I am giving one document at a time to avoid any confusion. Sir, this is a research paper which has conducted an exhaustive survey, a comprehensive survey on religious clothing and personal appearance. All the religious symbols are defined. I will not trouble the court, they are very familiar. Kindly come to the body of the paper. In addition to religious activities like praying, visiting houses of worship, or having a home altar, many Indians also display their religious observance through attire, including the use of special clothing, jewelry, and other aspects of their personal appearance such as beards. Half of Hindus, 52%, and Muslims, 50%, majority of Christians, 61%, for instance, say they generally wear a religious pendant. And most Sikh men and women wear a traditional metal bracelet known as kara and follow the distinctive Sikh practice of keeping their hair long. Many of these practices are gender specific. The vast majority of Muslim men say they wear a skull cap, 84%, and most also have a beard, 64%. Similarly, Sikh men largely have beards, 83%, and wear turbans, 69%. Among women, wearing a head covering outside the home is a common practice among Muslims, 89%, Sikhs, 86%, and Hindus, 59%. The practice of covering the head outside the home is less widespread among Buddhists, Christians. Nearly 2/3 of Muslim women in India, 64%, say they wear a burqa. A burqa is a covering for the whole body, including the face and head, but interviewers did not define the term for the respondents, leaving the exact definition, etc., etc. Then I will not trouble the court with the other. Kindly come to the next heading. Half or more Hindus, Muslims, Christians wear religious pendants. Then next heading, the details are given. Empirical data is provided. Most Hindu, Muslim, Sikh women cover their heads outside the home. Every college going student wears a dupatta. Kindly take judicial note of the fact, whether Muslim or Hindu or Christian. Likewise, the next chapter gives
the authenticity.
Sorry,
Professor,
please.
What is the authenticity of this paper?
Sir,
what is the representative character of the Times?
No, this is a research paper.
Apex Court said. No, Apex Court said.
Yes.
When research papers, so-called, are produced before the court, court should ascertain the authenticity and representative character of the findings in the research paper.
No,
therefore, I am asking this.
With great respect, I am not insisting upon acceptance of the empirical data that is provided in the paper. I am only bringing it to the notice of the court. The diversity prevalent in the country. Kindly look at the number of religious symbols, both among men and women, among students and non-students. Detailed category-wise details are given. I am not insisting on accepting this. Sir, if there are 100 symbols, why is the government picking up only hijab? Why is it not finding anything wrong with the other? Bangles are worn.
Unless
only for that limited.
I'm just telling the position of law says, unless a paper's authenticity is prima facie established by producing who authorized this research, who undertook this research, who approved this research, what are the research methodology principles on which paper is constructed, unless these are established, you can't just go by what it bears in our forehead.
No. With great respect, I am not insisting on accepting any of the data that is provided. Please consider the number of religious symbols which have been enumerated there. This honorable court may take judicial notice of this fact. These are all the religious symbols prevalent in the society. Hindus have their religious symbols. Sikhs have their religious symbols. Christians.
Only to the extent of plural symbols being provided.
Yes.
It only shows the plurality of the symbols. To that extent, we will take note.
I am only here to demonstrate the plurality of our society, the diversity that is prevalent in this society. Why is only hijab picked and chosen for this hostile discrimination? Is it not because of the religion? It is for that limited purpose to demonstrate the vast diversity in the society and the number of religious symbols among all sections of the society. Sir, in the army, turbans are allowed for the Sikhs.
We have taken note of this.
Yes.
So bangles are worn. Are they not religious symbols? I ask this question myself. Why you only pick up these poor Muslim girls? Now that is bad. Kindly show Article 15 specifically any discrimination. Constitution Clause 1 of prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. The state shall not discriminate against any citizen on grounds only of religion, race, sex, place of birth, or any other. This is only because of my religion that the petitioner is subjected to this. Only because of her religion. Because a dupatta is not banned, a bangle wearer is not sent out of the classroom, a bindi wearer is not sent out, a Christian girl carrying the crucifix. Every Christian carries a crucifix on her neck. They wear pendants. They are not touched. Why only these girls?
Oh, on the religion.
That's what.
So this is my next ground of attack on the impugned action.
You say that the Article 15 prohibits the discrimination on the ground of religion.
Yeah. Therefore, hijab being subjected to this hostile attitude.
It says headdress
Yes.
by anyone, not any particular society persons belonging to particular religion.
To all persons.
So all persons, they say about it. So how?
Hijab is worn only by Muslims. Sir, Gunga.
Suppose if a Hindu also wants to wear, he cannot.
If anyone else wears, then
Gunga.
whether it is permitted.
Gungat
Whether
is
it is
permitted. Yes, Gungat is permitted, not banned. Bangles are permitted. Is it not breaking the uniformity? Bangles are not.
We are talking about the headdress.
No, headdress is one religious symbol.
Headdress.
Sir, there are other
Whether it
reasons why I gave this paper to show how many religious symbols are there in the society. I just wanted to demonstrate the plurality of the use of symbols, religious symbols. Why only this? Why not the crucifix on the neck of a Christian student? Why not the turban of a Sikh student? Sir, the matter is no longer Vasintika, if I may say so with respect. Immediately after the Constitution came into force, even before the ink on the Constitution was dry, matter was taken before the Honorable Supreme Court. There were what are known as communal electorates. And for Etawah municipality in UP, elections were held on the basis of community for separate electors. That came up before the Honorable Supreme Court has declared it as void. AIR 1953 Supreme Court, page 384. Copies will be given by me.
AIR
1953 Supreme Court, page 384. May I pass on a copy of the judgment?
Communal electoral constituencies. That is.
Kindly come to page 385, just two small paragraphs. Para 3. Now it cannot be seriously. that any law providing for elections on the basis of separate electorates for
the members of religious communities.
Religious community.
Yes.
Separate electorate. It was hit by Article 15(1), that is the declaration of law, by a constitutional bench.
Yes. There is no dispute to that.
Para 4 reiterates this constitutional mandate to the state not to discriminate against any citizen on the ground inter alia of religion clearly extends to political as well as other rights and as other rights. So therefore, this directly applies on all fours to this thing. Likewise, in Rajasthan there was a police rule, 1960 Supreme Court. Yeah, 1960 Supreme Court. Mr. Tahir, can you give a copy of? Yeah, 1960 Supreme Court, page 1208. Kindly come to the second page of this document, this judgment. Para 7, only one para. So the facts were that under the particular enactment, if there is any special force provided to a place, the members of the community were required to bear the expenditure of that police force. Two communities, namely Harijans and Muslims, were exempted from payment of this duty. Now that is what was under challenge. Para 7 may kindly be true. Learned counsel for the state made a strenuous effort to show that the exemption of Harijan and Muslim inhabitants of the villages was in the impugned notification, not based only on the ground of caste or religion or the other criteria set out in Article 15(1), but on the ground that persons belonging to these two communities were found by the state not to have been guilty of the conduct which necessitated the stationing of the additional police force. It was the same argument as was addressed by the High Court and was rejected as observed court. Now this is a very strange argument that only persons of a certain community or caste were law-abiding citizens, while the members of other communities were not. Distinguishing elements may be found among members of any community or religion just as much as there may be saner elements among members of that community or religion. The view expressed by the learned judges is, in our opinion, correct. Even if it be that the bulk of the members of the community is exempted, or even if all of them were law-abiding, it was not contended on behalf of the state that there was no peaceful and law-abiding person in these 24 villages belonging to the other communities on whom the punitive levy had been directed to be made. In para 5F for the petition filed before the High Court, the respondent has averred that the aforesaid notification is ultraverse the Constitution of India, as it discriminates among the citizens on a village on the basis of their religion, race, or caste, inasmuch as it makes a distinction between persons professing the Mohammedan religion and others, also between persons who are Muslims and Harijans by caste and the rest. It therefore contravenes the provisions of Article 15. The answer to this by the state was in this term that is quoted. It would be seen that it is not the case of the state, even at the stage of the petition before the High Court, that there were no persons belonging to other communities who were peace-loving and law-abiding, though it might very well be said, that according to the state, the great majority of these other communities were inclined the other way. If so, it follows that the notification has discriminated against the law-abiding members of other communities and in favor of the Muslim and Harijan communities assuming that they are one of them was peace-loving and law-abiding on the basis of their caste or religion. If there were other grounds, they ought to have been stated in the notification. It is plain that the notification is directly contrary to the terms of 15.1 and that para 4 of the notification has incurred the condemnation as violating specific constitutional provision. In our opinion, the learned judges of the High Court were clearly right in striking down the paragraph.
All right, that we have seen.
So kindly consider this. No other religious symbol is considered in the improved government order. Why only hijab? Is it not because of their religion? I therefore very respectfully submit that the discrimination against Muslim girls is based purely on their religion. And therefore, first aid is.
Even if a person belonging to other community,
Please.
a lady belonging to, a girl belonging to other community, suffers from acacia, and to minimize the ugliness, she wears the headgear, comes to the school, she will not be permitted.
No, why? She is entitled for exemption. She can apply for exemption.
That's exemption.
No.
Exemption is another thing.
Sir, with
There
great
is a general rule.
hard cases,
Read your argument.
hard cases, bad law. Definitely, if there is a case where there is somebody, it is an exception, very rare exception. Definitely, they will be, they will not be barred because they are entitled to claim exemption, and we are not permitted to. We are not even heard. We are punished straight away, made to stand at the gate. Can there be a more draconian measure? Can they be called teachers who have shut us out of the classroom?
Yes.
Great respect, that analogy may not apply here for the simple reason that's a humanitarian case, which definitely anybody would be sympathetically viewing. Here it is full of prejudice because of the religion. We are not even heard. No notice. Simply shut out of the classroom by persons who have no authority or whatsoever under the act of the rules.
Yes.
All right.
So with this, I rest my second submission on the doctrine of discrimination based on religion. The third most important submission is that the goal of education is to promote plurality, not to promote uniformity or homogeneity, but to preserve heterogeneity. In fact, the world over, this has been very well recognized that the classroom should be a reflection of the diversity in the society. Honorable Supreme Court has also recognized in case Putswami's case more expressly. In Nalsa case, I'll place the judgments. I will not trouble the court with this thing.
Yes.
Yeah, may just give the relevant paragraphs. In 2008, 5 SCC page 33. Paras 41, 42.
Page number 2008, 5 SCC.
Page 33.
Read.
2008, 5 SCC page 33.
Paragraph?
Paragraph 41, 42, 45, 46, 54, 56 and 58, where the historic role of Akbar the Great in maintaining peace and harmony and diversity in the society has been expressly noted by the Honorable Secretary. In Navtej Singh Johar, where section 377 was struck down, 2018 10 SCC page 1.
$2,000?
2018 10 SCC page 1. Paras 97 by the Honorable Chief Justice. Para 4 and then para 610 by Justice Chalmeshu. Then in Valsamma versus University of Cochin, Valsamma versus University of Cochin, 1996, 3 SCC.
Yes.
Page 545. Paras 22 and 25.
These are for the proposition. I'll write down. We'll write down the proposition also. There should be no uniform at all.
No. This is for the proposition that heterogeneity should be maintained. Unity in diversity should be the motto. Plurality of the society should be third. Then when the Right to Education Act came into the force, the validity of it was under challenge. This was in the Society of Unaided Schools of Rajasthan, 2012, 6 SCC page 1. Paragraph 239, 240, 260, 239, 261. Heterogeneity should be maintained in a classroom is the goal of the new RT Education Act. This was a statement made by the Government of India, which has been placed onto. So my very respectful submission is that if people wearing turban can be in the army, why not a person sporting a religious symbol, which is her right to practice her religion, be allowed to attend classes? Sir, it's a draconian this, where universal education is, particularly girls' education. And court may take judicial note of the fact, among the girls Muslim girls are the least educated, least represented in classrooms. If they are shut out on the ground of such discrimination, that will be spelling a doomsday for their educational career. Very rarely they come to the college. Even such girls are being shut out on this pretext. Would be a very draconian measure. So with these submissions, I on other submissions, since it has already been elaborately argued, I do not want to cover. In reply, if it is necessary, I will get back to this court. I am grateful to the court for giving this patient here.
Thank you.
Grateful, my lord, unless there is some senior advocate designated from the Karnataka High Court, then I may be given a chance, my lord. First preference is from that.
Petition number 4. What is number? Please make of
Now we come to next case is 3038 of 2022. Mr. Yusuf Hatim.
Yes, my lord.
Yes, please make your submissions.
May I please, Your Lordship? Sorry. There's a lot of going on, so there's a lot of disturbance. I speak from Bombay, my lord, and there's some problem getting too much echo in the sound, and therefore, my lord, very often I have to repeat myself to make myself audible and to make myself properly understood by the court.
We are hearing.
Yes.
We are hearing you clearly.
Yes.
You
Your Lordship, no, the petitioner before Your Lordship, my lord, my petition are also the Muslim girls, my lord, and they have been in the pre-university, my lord, classes, my lord, and pursuing second pre-university course, and wearing the headgear, hijab, my lord, without any remark or blemishes in their academic program, my lord, and they have been, my lord, stopped from attending these classes from the 3rd of February 2022, my lord. And after this impugn order has come, they have been totally denied their right under Article 25, Red Book 19(1)(a), 21, and the right to education. And my lord, similar issues have been raised in other petitions. And my lord, I will not repeat many of the things which have already been adverted to by the my learned friends who preceded me. And my lord, I totally endorse, my lord, all their arguments advanced by Mr. Sanjay Hegde, Mr. Kamath, and also Professor Ravi Kumar, my lord, who just addressed and completed arguments at some time. But I seek your lordship indulgence, my lord, to merely elaborate one or two points very briefly, which I believe that they have touched upon it, but they have not made any elaborate arguments on that. The first point that I would like to say is this, that this particular impugn order suffers from manifest arbitrariness. It's manifestly arbitrary, and it also offers Article 14. Your lordships are well aware of the legal propositions authentically laid down by the Supreme Court, my lord, in the case of Saira Banu, pardon, I briefly draw your lordship's attention to only three paragraphs from Saira Banu's case, my lord. And when I make my submission as to how this whole exercise of preventing the Muslim girls from wearing hijab is manifestly arbitrary, my lord. Your lordship will see, my lord, it is, my lord, your lordship has got, I believe, the case in the compilation. It is 2017 9 SCC, page 1. 2017, volume 9, SSC, page 1, my lord. And my lord, I am reading very briefly only certain sentences from paragraph 100 at page 97, my lord. From the of my Lord the Justice Nariman.
On what proposition you want to cite this, Saira Banu?
Yes, no, it starts from 100 proposition.
On manifest arbitrariness.
Pardon?
You are citing.
Manifest arbitrariness.
All right.
Yeah. Pardon, my first is from paragraph 95, where the concept of arbitrariness and manifest arbitrariness is totally defined. Page paragraph 95 at page 95. On a reading of this judgment in natural resources allocation case, it is clear that this court did not put McDowell's as being an authority for the proposition that legislation can never be struck down as being arbitrary. Indeed, the court, after referring to all the earlier judgments, and Ajay Hamza in particular, which stated that the legislation can be struck down on the ground, in particular stated it can be struck down that it is arbitrary under Article 14, went on to conclude that arbitrariness, when it is when applied to legislation, cannot be used loosely. Instead, it broadly based test stating that if a constitutional infirmity is found, Article 14 will be interdict such infirmity. Such a constitution is found in Article 14 itself, wherever legislation is manifestly arbitrary, that is, when it is not reasonable, discriminatory, not transparent, capricious, biased with favoritism or nepotism, and not in pursuit of promotion of healthy competition and equitable treatment. Positively speaking, it should conform to the norms which are rational, informed with reason, and guided by public interest. Then, my Lord, your Lordship will turn to paragraph 100. The part which I have already read. That we have already seen that one of the tests of challenging the constitutionality of subordinate legislation is that subordinate legislation should not be manifest arbitrarily. Also, it is said that subordinate legislation can be challenged on any of the grounds available for challenge against plenary legislation. Now, my Lord, this is what is before your Lordship impugned order of the resolution is a piece of a subordinate legislation. The test of manifest arbitration is well explained in two judgments of the court and Kodai distilleries and state of Karnataka. And then, my lord, they have quoted paragraph 13 from the Kodai distilleries case. And trouble your lordship with that particular paragraph. It is next.
You may not, sir, you may not trouble us there because manifest arbitrariness has become a ground for striking down plenary legislations. So Kodai is overruled. Overruled decision need not be read. Now we have to show the decision is arbitrary. Earlier that was confined to delegated legislation, subordinate legislation, whatever name they may have, but never extended to the plenary legislations. Now they are included in plenary legislation. Now based on that premise, you can build the argument now.
Yes.
Overruled decisions.
Coming to how this act is arbitrary in the facts of the case, my lord.
Yes.
Now I will turn to the affidavit or the response that is filed by the government, my lord. And let us see, my lord, that how and in what circumstances this particular impugned action or the state action was taken, my lord. So your lordship may turn to the rules which are quoted, and Dr. Kumar has already pardon me?
Yes.
Your lordship will see that under these rules, that rule 11 provided that there should be a notice if you want to if you want to prescribe a uniform of 1 year prior notice.
That is for changing the uniform, not prescribing. Please read 11.
Every recognized may specify its own set of uniform. Such ones specified shall not be changed within a period of
For changing, therefore that applies where you want to change the uniform. For prescribing, no notice.
1 year advance notice to be given.
I'm applied to your law. When an education institution intends to change the uniform as specified in sub-rule 1, above it shall issue notice to parents in this regard at least 1 year in advance. Here in this particular case, what happens? That these girls are also wearing the headcraft since they've joined the institution.
Whether it was part of the uniform.
Not uniform prescribed, it does not also prescribe that nothing else should be done. Supposing a girl is wearing a glass, can you she wear the glass of a particular color only? And you put the different color of the glass that you are not permitted? You cannot take it so strictly and rigidly that when you say that this is the uniform, and uniform must also include something else that is also worn by the girl. Supposing she is not wearing, she is wearing a shoe and they are wearing chappals. It's not prescribed. And tomorrow's day you will not wear chappals, you will wear, and therefore you are prohibited from entering the school. So, my lord,
whether any headdress was prescribed in the uniform?
No, it was not prescribed. So, but the footprints were not prescribed.
It was neither part of the uniform nor prescribed as uniform.
That was a mandate that you have to wear the uniform, and it's not a case of the girls that they were not wearing uniform, but they are merely putting one more apparel on their head. Supposing, my lord, a girl comes barefooted one day, can she not come? She is wearing the uniform, but next day she says you will wear chappals. So you will not wear chappals or footwear in the classroom. And some girls start wearing chappal. And on that time, you go get out and you don't come into my class and stand out. So, my lord, these are the so therefore, my lord, what happens when we say uniform, we can't so strictly confine to the dress which is worn. But what is the practice which was there? What was the practice adopted in the school, and all of a sudden you change it? Is it not, my lord, reasonable or fair that you should give at least a notice to the other side? And now you will not be allowed to wear, or why should you not change? And the reason why we are not changing, The fairness would require that they should be informed. And the fairness also requires that they should be heard as to why they're insisting on changing. And thereafter, my lord, the parents teachers committee is also formed with a view not to create any kind of a trouble in the school. And that is also, that procedure is also not followed. That is the case of university.
You say that notice was required to be given first.
Notice
before.
Fairness requires that notice to be given. Rules may or may not require. But fairness requires, and that is one of the grounds on which I can raise the plea under Article 14. Is it a fair procedure? On the ground of fairness, it is required that they should have been heard. The parents should have been heard. The girls should have been heard. And if they did not want to give the notice, that they should have asked the parent-teachers committee which was formed. And try to, your lordship will see, that Rule 12, Sub-Rule 5, which is the internal page 11 of the government's response, my lord. The functions of the parent-teacher committee shall be as follows: to redress the grievances of the students and their parents. Why the parents and teachers committee was not consulted? With respect, this is a question that I'm putting to myself. Was it not fairness? What is that tearing hurry with it? The practice which is there in the school for nearly since the day when the girls are admitted, have taken admission into school, they want to change it. What is the need for this tearing hurry? The tearing hurry is this, that some boys are or some students are objecting, and are they objecting on the ground of the religion? Or this is it's an opposition to the girls' zone. That opposition as to why they want to wear a different dress, on what ground, on what they are claiming that. They are not placing the claim on any religion or any of the rights. And to accommodate, because you are objecting, you don't come. Is this fairness? All the more reason why they should have called the parent and to redress the grievances of students and their parents, if any. Call both the sides together, talk it over to them, and bring a solution. At home, the government did not even. So these are the grounds of manifest arbitrariness.
All right.
And this is being done only on the ground of this. And that point has been very elaborately explained by my learned friend, spoke to your court before me, and so I will not repeat those grounds.
All right. Now, anything else?
Not your lordship will see. Then your lordship will see that the fact that it is being done because of the opposition of some other students is also recorded in the impugned order, in the government response itself, and also in the impugned order. So it is partisan. So it is totally unfair, and therefore it falls within the mischief of the manifest arbitrariness, which is a part of Article 14, my lord, and therefore it has to be set aside. Now, your lordship will say that my learned friends Sanjay Hegde and Mr. Kamath elaborately explain the Article 25.
Yes. That we have done.
No, your lordship will see.
Now we come to.
No, your lordship will see. I want to one point that they have not stated, which I would like to slightly elaborately state before your lordship, and your lordship may give me some patient hearing on that. That under Article 25(1), when the right is based on Article 25(1) and also 19(1)(a), what is necessary is that the entertainment of a conscientious belief by a particular individual. Your Lordship knows very well that Article 25 deals with the individual's freedom of conscience. Now, Your Lordship may kindly please turn to Article 25. And the distinction that I want to draw is this.
What do you want to?
I'll tell you.
Yes.
I want to tell Your Lordship that when the blight is claimed under Article 25(1) as a matter of conscience, then it is not necessary to go into the question that whether that belief is held by that person is an integral part of his religion or not. The question whether a particular practice, religious practice, is within the integral part of the religion is relevant only under Article 26b. Then it talks of the denominational rights, and not when the person or the petitioner before Your Lordships are making the case under Article 25(1) about the religious belief. Now, Your Lordship, will see Article 25(1). Your Lordship are very familiar with the words, but I'm just emphasizing one thing. Subject to the public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience. But then, drawing distinction between the two, freedom of conscience and a right freely to practice and propagate religion. The conscience would mean is a very wider term. There are people who may not believe in God, yet they are entitled to that belief in conscience. There are people who believe in universality of religion. They may not accept any one particular religion, but they believe in all religions. They are entitled to that belief. And if they come before Your Lordship and say, this is my belief, I should be protected. And then the question, so what is the integral part of your religion? In my respectful submission, that is not necessary. And my Lord, this very issue is now being referred to the 9 judges bench, my Lord, and in reference from the Sabrimala's case, my Lord. And therefore, my Lord, this question, how far the court can interfere with the religious belief of the people and entertain all the arguments relating to that whether they are in consonance with this article or that article.
Yes.
But therefore, my Lord, in our case, my Lord, no doubt, my learned friend, Mr. Kamath, has dealt with that question and said it is an integral part. Wearing a hijab is an integral part, and there he has, my Lord, laid the basis for that by referring to his own pleadings and the reference to the certain Quranic verses over there.
We have understood. You are saying that it is not necessary that it should be an essential religious practice for the purpose of attracting Article 25(1).
And the belief has to be protected. And
Yes.
then you are that this particular act is also forms part. The belief also comes part of the freedom of expression in 1918. And Your Lordships are very, very much familiar with the Puttu Swami's case, my Lord. And my learned friend, Mr. Hegde, as well as Mr. Justice Kamath, referred to the view of Justice Chalameshwar, in which he said that a right to believe also a part of the freedom of expression contained in under Article 1A, 19(1)(a). That passage is read before Your Lordship. Now, having read that passage, my Lord, I will also like to draw only one more paragraph from Puttu Swami's judgment. Now, the subject begins, concept and Manekan interplay between the rights. Your Lordship has got that judgment, my Lord, that 2017-10 SCC page 1. And therefore, my Lord, starts with paragraph 21, and I will not, my Lord, read those paragraphs. And there they trace the history of the development of the entire theory of the interplay of those articles. And your lordship may directly come to the paragraph 24 by page 350. I will not read the whole paragraph, but only the relevant extracts from that paragraph, my lord. If your lordship may kindly see 1, 2, 3, 4, 5, 6. And the 7th line on the top of the paragraph, my lord. The jurisprudence foundation, your lordship got
Paragraph number?
24, my lord. 359. The jurisprudential foundation which held the field 66 years ago in MP Sharma and 50 years ago in Karak Singh has given way to what is now a settled position in constitutional law. Firstly, the fundamental rights emanate from the basic notions of liberty and dignity and the enumeration of some facets of liberty as distinctly projected rights under Article 19 does not denude Article 21. So not all the articles have to be read in conjunction with others, and one fundamental right reinforces the other. One doesn't denude the other. And it is expansive ambit. It is expansive ambit. Secondly, the validity of a law which infringes a fundamental right has to be tested not with reference to the object of state action, but on the basis of its effects on the guarantee of freedom. Now, your lordship will say that here the impact is important, not the object with which they are doing. What is important is that well, they want uniformity, they want discipline, but doing this, are you impacting the rights of the others and the rights of the petitioner or not? And here the impact is on my right of 25(1), freedom of expression, my right of expression 91A, my right to take education under Article 21. All this has to be sacrificed in the name of the so-called name of maintaining discipline in the court. Are there no other ways in which discipline in the court can be maintained? Why are the Muslim girls who conscientiously believe that we must wear the hijab should be put to a Hobson's choice now? It's a Hobson's choice that either you educate yourself or you look after your conscience. Why? Is this fairness? Is this a state action? Guarantees the freedom which are guaranteed in the Constitution. And this kind of Hobson's choice which is placed on the girls, my lord, should be disregarded. And then your lordship will see that this action which is they have launched upon is also opposed to fundamental duties of a citizen, guaranteed under Article 51A, and my lord is also shown and incorporated a statutory form in Section 7(2) of the Karnataka High Education Act. Your lordship says Section 2, Karnataka Education Act. Your lordship are very familiar, but they are actually reproduced in the Act itself. The lordship may turn to subsection 7 of the Karnataka Act, and we say that under subsection 1 may also include schemes in respect of and come to clause D. Clause D. 7 subsection 2 clause D. Inculcation of the sense of the following duties of citizens enshrined in the Constitution, namely, and then my lord, they are enlisting all the duties, and my lord, your lordship may see the Roman 5 to promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional, and sectional diversities to renounce practices derogatory to the dignity of human. So, my lord, this particular practice, are we supposing to promote harmony or dissension on the basis that your wearing particular hijab is disturbing us? Is it not a violation of the constitutional duty, the fundamental duty which is expressed in Article 51A? And incorporated, why is it incorporated by the legislature, my lord, in subsection 2? And your lordship has just section 133. In what circumstances section 133 can be invoked, my lord? It is for the purposes of the act. The act is to promote harmony. The purpose of the act is not to create a dissension among the students. And when the established practice is there, then why should we have this kind of an attitude? Why should the school or why should the government come out with this type of an activity or this type of impugned sub-legislation? Then harmony, the spirit of common brotherhood, are we promoting that? Among all the people of India, transcending religious, linguistic, regional, social diversity, renounce politics, derogatory dignity. That is
Yes.
then my lord, very next, value and preserve the rich heritage of a composite culture. The Constitution itself, my lord, takes into account the diversity that exists in our country.
All right, Mr. Yusuf, we have understood what you are saying. Will you be able to finish today? Because now we are at the end of the day.
If your lordship may give me some time tomorrow, I'll be happy.
Any other point to elaborate?
Yes, my lord. The another point is very important point, my lord, that this is also, my lord, mainly referred to by Mr. Kamath in his, but he has not elaborated that proposition, the doctrine of proportionality. The doctrine of proportionality, my lord, is totally ignored. I will like to dilate a little, my lord. I will not take much time. I will not repeat whatever my learned friends have said. I am merely trying to elaborate some points that they have clearly referred to. And I am making a very important point.
That you elaborate in your written submission. Give the written submission, we will consider.
Give me 10 minutes more. I will just refer to it, my lord. I'll just refer to it. Your lordship,
yes, we have noted.
Doctrine of
proportionality, you want to elaborate on that, we have already noted it. So if you want to elaborate it, give it in written submission, we will
then your
see
lordship,
that.
either you give me 10 minutes today or you give me 10 minutes tomorrow. I will not go in detail on it. Because what is the doctrine of proportionality, my lord?
What more you want?
Components, my lord? That I just want to read, my lord, and I want to show to your lordship a judgment of the Supreme Court, my lord, in which they have shown what is meant by doctrine of proportionality and how that has been totally ignored here, my lord. If your lordship gives me 10 minutes more today or 10 minutes tomorrow, I'll finish it. And I promise your lordship, I will not, and as your lordship has been kind enough to give us the permission to put a written submission.
Finish your arguments today, so that we may hear the others.
Your lordship. Much obliged, my lord. My lord, I will request your lordship to judgment. My lord, it is in the case of Modern Dental College and Research Center and others versus State of Madhya Pradesh, reported in 2016, 7 Supreme Court cases, page 353.
Yes.
I'm sorry, my lord. I request my instructing advocate, my lord, to hand over the copies of those judgments to your lordships, my lord.
Yes. Paragraph?
Yeah, Lord. Paragraph 59, my lord. It is at page paragraph 59. 373. No? My Lord, at page 412.
Yes.
The Lordship is a page, paragraph 59, my Lord, I will skip it because they merely reproduce 96. The Lordships are very familiar with it. Then, my Lord, I read sections, paragraph 60, my Lord, which is of utmost importance. Another significant feature which can be noticed from the reading of the aforesaid clause is that the state is empowered to make any law relating to the professional and technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. Thus, while examining as to whether the impugned provisions of the statute and rules amount to reasonable restrictions and are brought about in the interest of general public, the exercise that is required to be undertaken is the balancing of fundamental rights to carry on occupation on one hand and the restrictions imposed on the other hand. This is what is known as the doctrine of proportionality. Jurisprudentially, proportionality can be defined as the set of rules determining the necessary and sufficient conditions for limitations of a constitutionally protected right by a law to constitutionally permissible. According to Aharon Barak, former Chief Justice of Supreme Court of Israel, there are 4 subcomponents of proportionality which need to be satisfied. A limitation of a constitutional right will be constitutionally permissible. It is designated for a proper purpose. Now, my Lord, your first thing, your Lordship, is our submission that this particular impugned action is not advancing the purpose at all. Purpose of the act. The measure undertaken to effectuate such a limitation are rationally connected to the fulfillment of that purpose. The advancement, the harmony is the real purpose of the act. And the measure taken by them will go much against the provision of harmony and also the fundamental duties that are enumerated in the Article 51A. Then 3, measures undertaken are necessary in that there are no alternative measures that can similarly achieve the same purpose with a lesser degree of limitation. Now, why not, my Lord, this? It's assuming that they want to have a uniformity, want to have discipline, then why not consult? Why not consult the people who are the stakeholder and who are the person affected, whose rights are impacted? Sorry, Lord. That there needs to be a proper relationship. Proportionality is stricto sensu of balancing between the importance of achieving the proper purpose and a social importance of preventing the limitation of the constitutional right. What is the constitutional right, my Lord, here, which are infected and infringed? Article 25(1), right to my conscience, right to my expression, my Lord, right to have my education, my Lord. That's totally disproportionate. Totally disproportionate.
All right.
This is the ground on which, my Lord, we attack. This in addition to all the grounds which are mentioned by my learned friends, the 3 of my learned friends who preceded me in addressing your Lordship. And, my Lord, I humbly, my Lord, thank your Lordships, my Lord, for inexhaustible patience in hearing this matter.
All right, thank you.
The Lordship will give me the liberty, my Lord, to file my written submissions, my Lord. My Lord, your Lordship may prescribe the time within which we have to give. And, my Lord, I want to make clear, my Lord, one thing, that these are all grounds which are advancing at a stage of interim stage. I think the hearing of the interim application is going on, and not the final hearing. There is some confusion in my mind, my Lord. Your Lordship may forgive me for putting it before your Lordship.
Yes, what?
Interim applications are not yet disposed of. So this is the hearing on interim applications. Otherwise, we would like to argue.
We do not know how you people have started arguing. We have started hearing. That is all.
What are we arguing? Because the Lordship have already passed.
I don't know whether you are making final submission or making your submission on interim relief application because that has not been clarified.
Final, my lord, 10 hours your lordships have been hearing. It has to come to an end. It cannot go on.
And what are the interim orders? How is the
It has to be
interim
final, my lord.
disposed of?
Your lordships have been
My lord,
so
we will
gracious in
like
giving
to
such
know
a
how
time.
the interim
Let it be
orders are
final.
disposed of, interim applications disposed of. Your lordship has granted certain.
We have not disposed of any interim relief application. Let it be very clear.
My lord, sir, hearing
But
is
I
final.
think, my lord, these are the
On the first day, we had passed some interlocutory.
establish only prima facie.
That is all.
At interim stage, my lord, you have to establish only prima facie case.
All right. We have heard Professor Ravi Verma Kumar in writ petition number 2347 of 2022. Mr. Yusuf Hatem Mukhalde, learned senior advocate,
Muchala.
has argued on writ petition 3038 of 2022 for the petitioners. Put up tomorrow. Now, put up tomorrow at 2:30. We'll continue. We are left with writ petition number 3148
Please.
of 2022. That is a PIN.
To start with, Milord.
3424 of 22. That is also a PIN.
Please.
This 3424-22, there are some office objections which have not been removed. So only 2 writ petitions have been left
Please.
to be heard on behalf of the petitioners.
Tomorrow I may permit it to start with, Milord. So I'll conclude within 10 minutes, Milord.
My lord, my petition 3418 is also complete. I have been waiting for
3148 is my petition.
3418. That's also complete. Is also required to be heard whenever your lordships will get time.
My lords, I'm party in person, Dr. Vinod
We
Kulkarni.
make one
PI
submission.
in 3312.
One submission.
In 3 minutes, I'll finish off my submission, my lords.
In WP 2146, IA number 5 has been filed. Court may kindly recollect yesterday for some technical reasons it was not considered. A proper application has now been made, IA number 5, seeking a clarification, saying that its students will abide by the whatever uniform insisting upon, just to use the same dupatta to cover the head. Only no additional dress, sir. Seeking a clarification. Let the students get back to the class.
My lord, I am a petitioner in person. My lord,
Just a minute.
Number 5.
Just a minute.
IA number 5 may kindly be perused. Kindly look at the
IA
page.
number 5 of 2022 in WP number 2146. Planet Advocate General, appearing for respondents, informed that he has received the copy of this application. He intends to file the objections to this application. He prays for is allowed. 2 days time to file the objections.
my
My
lord,
lord, before writing, I make one humble submission, my lord.
petitioner in person.
I connected to your lordship from Delhi, my lord. I have one submission. My petition was, your lordship was pleased yesterday to club my petition 3418. That was an order passed by your lordship. Whenever your lordship will get time after hearing other matters, my matter may be also. That's a separate.
Which is your writ petition?
3418 or 20222. Josefa is title. Yes. 3418.
3148 hai.
Yes.
It
yes.
is 3148.
Yes, my lord. Josefa. Title is Josefa. Yes.
Yes, we will hear you.
Please, your
My lord, I am petitioning in person. I filed intervention petition in writ petition 2347 of 2022 today itself. So either I may be granted time or this is very small petition. In that we have given the reasons that it should be not allowed their petition. So those grounds are, we have pointed out in our intervention petition. So that we may be granted time, or it can be read by the Lordship. Today it was filed, my lord.
Written submission. What do you have filed?
Intervention petition, my lord.
Intervention applications will not hear. Sorry.
But
We'll hear the petition counsel only.
My lord can read. The time may be not granted with the very material points for the assistance of.
If required only, then we will permit. Otherwise, not.
Yes.
Take it that we are not permitting anyone to intervene.
No, but that could be read, my lord, for the administration of justice. That lordship, that's a very small petition.
Now there's one IA filed by Mr. K. Kotwal, advocate. R. Kotwal.
Please, Lords.
Yes,
Please,
you
please,
have moved an
Lords.
application for impleading
Please,
as proposed.
I'm not pressing that application. I am not pressing that IA number 1, my lords. Since I have already
Because
filed
what we filed, we have also filed an impleading. Why not cost should be
I'm
imposed?
not pressing the IA number 1.
How
IA number 1 is
without
not pressed, my lord.
86 है ना?
that IA 1 of 2022 in repetition 2347 is dismissed as not pressed.
Please, oblige, my lord.
My lord, I stand corrected by like 3586.
Does not want to press this application. Dismissed as not pressed.
My lord, 3586 is my petition. Sorry, my lord. I stand corrected. 3586. 3586.
Yes.
Yes,
We'll hear you.
please.
We'll hear you when you're
Please, grateful, my lord. I'm highly obliged.
Lordship, may I make one submission, Lordship? In first two petition, state has filed objection, Lordship. Permission may be granted to me to file rejoinders, Lordship. Because some facts they have stated, I'll file written rejoinder.
Whatever you file it. Nobody will stop.
My lord, I am Dr. Kulkarni, party in person in WP 3312. If you can kindly hear me for 2 or 3 minutes, I'll be obliged, my lords.
Yes.
Please, Mudaj.
May it please, madam.
May it please, my lords.
Lords, we are unable to see the honorable court, madam. May it please, my lord.
May it so please, my lords.
My lord, I beg to appear for the petitioners in my lord's WP 2880 of 2022.
My lords, I appear in 2146 of 22, which is the first case.
Please give the name.
Yes, my lord.
Lords,
That is Miss Aisha Sanjay, if I don't know.
Let me. Mine is the first case. If your lordship pleases, writ petition 2146 of 22. It is Aisha Hajir Almas.
2146 of
22.
yes.
Aisha Hajir Almas. That is the case from Udupi. My learned friend appears, Mr. Devdutt Kamath appears in the
Lords,
case
in
from Kundapur.
2880 of 2022, my lords. Lord, this petition was heard, my lord, before the learned single judge, my lords, at length on day before yesterday. So, my lord, if I can just make a few brief, my lord, submissions, then my learned friend can.
You are appearing in 2880.
That's right, my lord. That's right, my lord. Lords, I have prepared a written note. Lords, Sanjay, just
may I begin? I have something which will save the time of the court. Please, my lords. My lords, there are several cases out here, and the referral by the learned single judge was largely on the question of whether this is an essential religious practice. And that question, no doubt, squarely arises. It was heard at length. Mr. Kamath is right. He did address the court for nearly a day on that. But, my lords, there is also a principle in law which says that constitutional questions necessarily be decided if they can be decided on other statutory grounds. My lords, in this case, it will be my respectful submission that while I fully adopt and I will be also arguing the constitutional questions, there are also statutory questions and questions on the rules on which the facts of this case may be disposed of. Please, my lords. My lords, the lead judgment for this principle is a judge. We will
have to understand what are the questions involved.
Please, my lords.
Then only we can decide.
That's right, my lord.
Please, my lords. My lords,
first give the key facts of the case.
Please, my lords.
Give the key facts of the case and then come to the legal position.
Please, my lords. The brief facts of the case that I represent, which started off this entire chain of events, arise from my hometown of Udupi, my lords. In the government PUC college there, 2146 of 2020. My lords, in this petition, the brief facts are set out at para 5 on page 12.
Yes, a direction has been sought to attend classes with their head scarf without any bias and discrimination.
Please, man.
Yes.
My lords, may I just place the facts as to what happened? And I'm aware that there is no counter as yet filed by the private respondents because they probably were served only yesterday. My lords, it appears to me on my reading of the facts,
whether the state has filed the
state has filed a response. The state has filed a comprehensive response on law. On law.
All right.
Please, my lords. The only reason that I'm placing the facts are that it appears on my reading of the facts that it was a small thing within a college, which probably due to lack of timely administration has been allowed to go beyond control. The para 5, my lords, may I read? May I please? Para 5 of the petition, my lord. I'm sorry, my lords, I was waiting for. There seems to be some disturbance, but if your lordships can't hear me, please tell me.
Yes,
please,
yes, we are.
Please,
yes, we are hearing you. Yes.
Please, my lords. The petitioners are students of the government pre-university girls' college and are wearing their regular headscarf over the college uniform And respondents 6, 7, and 13, who are teachers there and the principal, insisted that the petitioners remove the headscarf by shaming them due to their conduct and invoking their religious identity. In fact, in spite of this, the petitioner continued the same, convincing their alma maters that it is part of their religious and social culture and wearing headscarf is not coming in the way of school discipline and their education. In the month of August 2020, respondents 6 and 7 rebuked the petitioners and told them that their parents had sent consent letter at the time of admission, accepting terms and conditions of the school, and specifically admitted that their wards won't wear the headscarf, so now they can't breach the same. Respondents number 6 to 14, whenever they found the petitioner anywhere in the college, scolded them, threatened them with marking absent in their attendance and not awarding internal marks. Respondent number 13 specifically informed petitioner number 5 that in the past also some girls used to wear headscarf to teach a lesson to them. She incited other students to pull their scarf. If you and other students don't fall in line, they will have to face the same treatment. Since September 2021, the petitioners faced discrimination in their class, and whenever the respondent took their classes, removed the petitioners from their class, marked them absent, made them stand outside as the class as punishment, and it is still continuing till today. In the month of December, parents of the petitioner went in to speak to the respondent number 6, that is the principal. He replied that now exams are going on, he will discuss the issue after exam. And when they demanded about the consent letter, which the college teachers used to refer to the petitioners, then the respondent number 6 candidly accepted that there's no specific condition regarding the headscarf and it is common form regarding maintaining school rules and discipline. From the last week of December 21, after the exam class teacher did not allow the petitioner students to allow class, used to send into the respondent number 6 office to take permission and inform them either to remove their headscarf or get permission from the principal through their parents. Even when their parents came to college to speak to the principal, respondent number 4, they compelled them to wait the whole day without meeting. The conduct of the respondents 4 to 12 appeared to be to frustrate the petitioners and their parents and compel them to concede before them. On 30th of December 2021, seeing no result, the students approached respondents 3 and 4, who are the district education officers, with their representation to intervene in the matter, finished their ordeal, and after receiving the representation, respondent 3 called the principal and scolded him for not allowing petitioners to attend class and directed him to allow the student immediately. Copy of the presentations are there. On 1st of January 2022, New Year's Day, respondent 6, the principal called a meeting of the college development committee, which had no legal sanctity and in composition of political entities to interfere in the management and functioning of the college for the political agenda. The chairman of the CDC, respondent 15, declared that the petitioners will not wear headscarf. If they continue, then the other students, according to their narrations, Hindu students, will wear mufflers, saffron shawls to counter them and blend the issue into a communal color. After this meeting, the petitioners were not allowed to attend the college on all working days and were made to sit outside of court classroom like a culprit on 13th January. Seeing no hope and being targeted from every corner, petitioners thought of doing a protest in front of their college gate along with their petitioners to seek their right of education, which was continually denied. At that time, respondent 6 principal called the local media at the instance of respondent 16, the MLA, who took petitioners with placard to circulate in social and electronic media to divide society mallards. Then on 14th of January, the petitioners went to the college. That time, the principal called them in his chamber, scolded them for conducting protests in front of college and making a media issue. And subsequently, he called the respondent to write an apology letter. The respondents threatened petitioners with their gestures and gave a blank paper to forcefully write apology. When they refused, they called respondent number 13 as well, who manhandled them physically and threatened to spoil their education completely, and they cannot help as entire system is against them. Then, my lords, then other leaders got on, but this is the basic conspectus. So the reason
we have understood the problem. Yes.
Please, my lords. My respectful submission is that I have gone through the entire act, through the rules, and also an interpretation of the rules. My respectful submission is that in the Act, in the Karnataka Education Act of 1983, there is no specific provision which deals with uniform.
Do you mean to say that there shall not be any uniform?
Please, my lord, I don't mean to say, let me complete the argument. My lords, there is no provision for a uniform. The state relies on certain rules, which
just one thing. We will just make a request to the media in general that please don't report any observations made by the court during the arguments without seeing the order which we will pass ultimately. So there is a request to the media in general that please don't report our observations in the media, but in social media, in newspapers or anywhere else, unless you go through the order which is passed or you understand the entire thing. It is not proper that only some observations are reported here and there without realizing the repercussions of that.
Oral observations.
Yes, oral observations.
We are really grateful, my lord.
We
are really grateful for that, my lord, because sometimes whatever your lordships, my lord, speak, sometimes is reported, misreported, etc. We are really grateful, my lord, for that observation.
Yes.
We are grateful, my lords. My lords, while I was preparing for this matter, I recollected that your lordship is from Lucknow, which speaks of delicacy of language and exquisite manners, my lords. And there is a phrase from Lucknow which would help all of us. Muskuraiye aap Lucknow mein hai. And it is in that
spirit. Aap Bangalore mein.
Bilkul. My lords, the thing is that matters may appear big, matters may have grave consequences.
Yes.
But if there is a certain lightness of touch and an openness of heart, there is nothing that this country cannot achieve.
Yes.
My lords, so I was on the point that in the 1983 Act, there is no provision for uniform. And my lords, let me tell my lords that I was in Karnataka, in college, in Pius College, around that time, 1980 to 1982, I was in pre-university there. And we did not have any uniform. The question of uniform in not being in the Act was probably because at that point of time, the educational experience was, and seriously, that many a time a child could not go into a school because the parents could not afford uniforms. That time there were no government schemes for provision of uniforms. Sometimes there were cases where two children shared one set of uniform, so one child went to school, the other child did not. And so uniforms, by and large, were a school phenomenon, and primarily because it was easy to identify school children if they got lost, if they ran away from school.
Yes.
And when young teenagers on the verge of adulthood stepped into junior colleges, stepped into colleges, they walked out of uniform. Uniforms for college, my lords, came in much later, and they have come in due to the application of rules. And if memory serves me right, it all started in Tamil Nadu in a set of institutions, private institutions, which were engineering colleges with the ODR group of institutions, which were owned by a former policeman. And from there on, it came back into the colleges because there was some feeling that uniforms in colleges would prevent fashion shows and whatnot. This is a broad history of the event. It need not trouble your lordships. I am only putting it in the context of why there is no provision for uniform in the Act. Now there are two sets of rules. There are please, my lords.
Yes.
There are the Karnataka Educational Institutions Classification, Regulation and Prescription of Curricular Rules of 1995. The 95 rules have rule number 11, which the state relies on.
Yes.
My lords, there the rule says please, my lords, just give me 1 minute. And keep the 2006 rules. Provision of
'95.
Yes.
Provision of uniform, clothing, textbooks, etc. Each recognized educational institution may specify its own set of uniform. Such uniform, once specified, shall not be changed within the period of next 5 years. When an educational institution intends to change the uniform as specified in sub-rule 1, it shall issue notice to parents, etc., etc. And then purchase of uniform and textbooks from the school or shop and stitching of uniform with tailors shall be at the option of the student or his parents. These rules, in my respectful submission, basically were for schools. If your lordship sees, that will be, these rules are intended to cover largely the schools. Your lordships will see that rule 3, which would illustrate prescription of classes relating to primary and secondary education for the purpose of clause 25 and 32 of section 2. Primary education shall be classes from 1st to 7th standard, with 1st to 4th as lower primary, 5th to 6th as upper primary. Secondary education shall have classes from 7th
Say that
standard.
provision of rule 11 is not applicable to pre-university institutions.
Please, my lords. Pre-university is 2006. And the 2006 rules no provisions for uniform.
Yes.
Now, my lords, what the state and the college authorities rely on is a resolution which my learned friend Mr. Tahir, if he is in court, will probably hand over in a separate printout.
Yes.
Which has a prescription of a uniform for in this particular case. It is
660.
Because the original is in Kannada, my lords, and my lords, there also is a translation that we have attempted. But in a sense, the prescription is at clause 4, if I'm not mistaken. Which roughly translates into the school uniform which was used last year, that is blue color chudidar pant white and blue checks, top and matching color shawl to be worn on the shoulders.
Yes.
Please, my lords. Now, my lords, there is, as I told your lordship, A, there is no provision. B, there is no penalty. In case the uniform is not worn or improperly worn or incorrectly worn, there is no prescribed penalty. And even if there was a penalty which was prescribed, your lordships could have then checked on whether such a penalty of absolute expulsion, keeping children away totally from education, would be proportionate. My lords, if your lordship, I'm sorry, I'll wait.
Yes.
If your lordship turns to the Act itself, the Karnataka Education Act of 1983, the penalties prescribed in Chapter 17 are also largely for college managements. Section 113 onwards, my lords.
Yes.
My lords, largely they are financial. It will be punished with a fine which may extend to 25 rupees for contravention of Section 17. If a parent fails to comply with an attendance order passed under Section 17, he shall on conviction be punished with a fine not exceeding 2 rupees. Then there are penalties for ragging, for copying at exams, loitering near an examination center, malpractices, and so on and so forth, my lords. But because there was no provision for a uniform, there is also no question of any penalty for want of a uniform or for an infraction of the uniform code. Now, please, my lords.
Yes.
Now, my lords, to make things simpler and specifically because we are in a video conference, my lords, I would request my learned friend, Mr. Tahir, to hand over my submission only on the administrative law aspect of this matter. My lords, I have separately drawn it up. As far as the constitutional questions are concerned.
Lords, just one, lordships may, lords, hear us at your lordship's pleasure. But just one fact which I wanted to bring to your lordship's notice, my lord, is that in Mr. Hegde's petition, my lord, there is a subsequent GO which probably has not been impugned. And my lord, that GO is the basis, my lord, of the further action which has been taken by the state. So therefore, my lord, the state today is contending that there is a GO. Pursuant to the GO, my lord, there are certain consequences which follow. So, my lord, lordships may have to hear, my lord, the GO issue first, because all this petition was filed prior to the GO, my lord. So, therefore,
for you people to decide who will argue first.
Yes, my lord. So, I would request, my lord, since the GO,
decide who will argue first.
Yes, my lord.
Please, my lord, let me complete.
Yes, yes. So I was only requesting, my lord, that Mr. Hegde will bear with me. I'll just finish, my lord, in half an hour, not more. So because this my learned petition doesn't concern the GO at all, my lord.
No, Mr. Kamath.
Yes, my lord.
Mr. Hegde has started the argument.
Yes, yes, my lord.
Let him complete his argument.
Very well, my lord. Yes, as far as the GO is concerned,
we are not in a hurry. We will hear you all at length.
We are grateful, my lord. We are absolutely confident, my lord.
Yes.
And actually, we are grateful that your lordships took so much, my lord, interest and, my lord, constituted the bench, my lord, despite the pressure of your lordship's time. We are, my lord, really grateful for that, my lord.
Now let him complete his submission. Then you
yes, my lord. On the GO, I will make submissions, my lord.
Yes, yes. Yes, Mr. Hegde.
My lords, I have one request from Mr. Hegde, my lords. I am for the non-state parties contesting respondents. I would request Mr. Hegde to instruct his juniors to email that note, my lord, so that we can follow what he's saying. We are in different locations. We don't have the benefit of that note.
It will be done. It will be done in the next.
You both are friends.
I'm sorry,
yes,
my lord.
My lords, friends and neighbors in Delhi, my lords.
Yes.
We are neighbors in Delhi, but Mr. Puvaya is today in Bangalore, I believe.
Oh, I don't.
And in fact, when I said Muskuraiye Lucknow mein hai, it was Mr. Puvaya who first called me up and said, smile a bit more when he saw me rather. Please.
Yes,
I'm sorry, my lords. I have one request for the court master. My junior who's assisting me Mr. Pranjal Kishore keeps getting logged out from the proceedings and he can't follow instructions. He's in the waiting room. If he may kindly let in.
Somebody add him.
Please, my lords. Please send written submissions over to Mr. Puvaya and the others and anyone else. Please, my lords.
Yes.
My lords, the petitioners.
Written submission, Mr. Hegde, for the final hearing.
My lords, yes, for the final hearing, insofar as the administrative law aspect is concerned. If your lordship wants to wants me to concentrate on the interim order today.
No. We are not saying anything.
Please,
we have just started the hearing.
Please, my lords.
We just want to understand that in what manner you people want to argue.
Please, my lords.
If it is for the final hearing, well and good. There is no problem.
Please, my lords. My lords, I am mindful of court's time. I am also aware of the pressures on the court, specifically in constituting a 3-judge bench, which would also involve that many other benches get disrupted and many people. It is my respectful submission, my lords.
Yes, it is good of you that you are mindful of that, and let us.
My lords, that is why, my lord, I second, my lord, what my learned friend has said. Would your lordships hear us on the interim, my lord's arrangement? Because lordships, my lord, will decide this issue finally, my lord. There is no difficulty, my lord. Your lordships, my lord, are under pressure of time. Lords, we are in your lordships' hands. But, my lord, the urgency is this, that, my lord, these students, my lord, are outside the college. My lord, their classes, their exams are, my lord, supposed to be held sometime in March, my lord. There is an urgency, my lord, that at least some interim arrangement in the meanwhile should be worked out. My lords, let me complete. My lord, I have not finished.
In fact, when I would submit before your lordship, there is some subsequent development which has taken place in this matter.
Yes.
And the subsequent development which has taken place is quite grave. I must bring to lordship's notice is that pursuant to this petitions being filed before your lordships, on the allegation that they were kept out because they were wearing headscarf. But unfortunately or fortunately for whatever reason, there have been another set of students who are coming now to the colleges wearing bhagwa or saffron shawls, saying that also depicts our religious symbol and we must be permitted. But this led to a large amount of commotion and some sort of disturbance in educational institutions, for which the state government took a decision to close down the institutions for 3 days, which expires on Friday. But it's in this context, in fact, I wanted to make that submission before your lordships, but since Mr. Hegde started, what I can. Therefore, in that context, my submission before your lordships would be. Notwithstanding the claims and counter claims which is sought to be made before your lordships, an arrangement requires to be made, but which would be conducive ultimately for the educational institution concerned. Now, but as on today, but there is a order passed by the state government stating all that we have said is each educational institution shall decide its own uniform. We have not said that this should be the uniform, this should not be the uniform. Now, pursuant to which, what some institutions have taken a decision, what should be the uniform. The question is not whether any of the students would, in disregard to that, those decisions will go and take part in the institution. Pending that, but now of course, for two broad issues. One, now they have said that the government did not have the power to pass an order. Secondly, the larger question of Article 25, but which they say is inherent within the religion, its activity itself. It's part of an integral part of the religion to wear a headscarf. Therefore, by preventing me from participating in the institution, you are violating 25. That seems to be the larger argument. Pending that, lords, my submission and my lords may straight away record my submission. We need to start the institution. We want the children to come to the college. But we can't start the institution in this atmosphere where one set of the students say they will come and wearing headscarf, the other person say that we will have shawls, etc., depicting their religious symbol. We say, Lord, that we want to start the educational institutions. We want a very congenial atmosphere among students. Pending disposal of a final education, this is one option which the lordships may kindly examine. But they must go back to the status quo ante. But
Lord, there is absolutely
any particular.
Lord,
no, let me complete.
I'm sorry. I can't speak. I don't know. I'm sorry.
Without insisting on any particular dress code, whatever has been prescribed by each of the college development council, they must adhere as on today. Subject to, of course, not finally, if lordships are to hold that there really exists a fundamental right, then consequences. But this is something which I want to place on record. So as a state board, we are concerned with the apart from the law and order situation, about the plight of the students today. There are large number of students who are no way concerned with them, but they have been now kept away from the educational institution. It has to start in this manner. I am placing on record this arrangement will cause no prejudice. In fact, it will facilitate the running of this education.
That the first concern of everyone should be that at the earliest, the education institutions shall reopen and they shall start imparting education to the students. All these issues which are there, they are before the court, and then the court will consider them.
Absolutely.
But whatever is that, we all have to agree that some sort of arrangement shall be made where the education shall not suffer.
Absolutely.
Not only that,
we don't think that there can be any dispute to this. That our endeavor should be that the education of the students shall immediately start and without any disturbance.
And because of this pandemic, already 1.5 years the students have left or kept away.
Yes, now things were coming to back to track, coming to track again. But now this issue has started where the schools have to be closed. This is not a good situation.
It's not a good thing, but this has to be diffused. But therefore, this arrangement,
I completely agree, my lord, with what the learned AG has said, that the schools and colleges should reopen at the earnest. And my lord, there is absolutely no joining issue with that, my lord. And my learned friends also will agree. My lord, what I was suggesting is, as Mr. Hegde put it, my lord, this is not a case of uniform, my lord. My lords, nobody is saying this is not a case, my lord, where the students are saying we will wear a different uniform. Please, my lord, as far as my clients are concerned, this is not the issue at all. The issue is simply this: the students will wear the school uniform. The only question is, my lord, that they want to wear a headscarf of the same color as the uniform. And my lord, the state is today saying by a GO that they can't wear that headscarf. Lord, that is the crucial issue. It is not about uniform, my lord. And therefore, my lord, I respectfully submit that in the interim, my lords, my lord, these students have been, my lord, going to the school wearing the uniform and, my lords, wearing their headscarf. My lords, let that, my lords, situation continue. Let your, my lords, lordships, my lord, take whatever time it takes, my lord, to decide this issue. In the meanwhile, my lord, it is their customary practice not to wear a headscarf over the head, my lord. And there are traditions which are there all over the country, my lord. And these are innocuous traditions, my lord. It doesn't harm anybody. This is not a question of public order. This is not a dangerous practice, my lord, where the state comes in and says, no, this offends somebody else's right. So therefore, in the interim, my lord, let them continue wearing the same uniform, my lord, the headscarf of the same color, and let them commence going to school, my lord. And what the state, just one more submission, my lord. The state today says, my lord, I heard the learned AG saying that, look here, we have not done anything. We have only asked the school committees to take a decision. My lord, this is totally wrong. The state, my lord, is playing, my lord, by the fire. And I want to say this. In the GO, my lord, kindly see the GO. The GO has not been placed before your lordships. The GO says, my lord, kindly, if my learned friend can just give an English translation to the Honorable Court. The GO says, my lord, that the headscarf is not a part of religious practice. My lord, and then the state, and thereafter, my lord, the discretion has been given to the state committee to decide. Now, my lords, our fundamental rights in this country, my lord, be subject or hostage to some school committee. Lord, is it what the state is saying? Just have a look at the GO, my lord.
Kindly,
Lord, I want to make submissions. Now, I didn't interrupt the learned. There has to be some discipline, my lord. Lord, I am making a submission. Lord, I am making a submission. The AG will not, my lord, interrupt me. Lord, we are in your lordship's hand. This is the court of law. And I hope, my lord, there is freedom of speech and expression here. Lord, just have a look at, my lord, the GO. We have made an English translation. And if I can just place, I had placed this before Honorable Justice Dixit, my lord, for at length. But if I can just place this GO, my lord, this is the basis of the state's decision. Lord, if I can just skip the recitals, just have a look at, my lord, page 2. Just before the quotation, my lord. The question relating to uniform dress code over individual dressing choices has come up in several cases before the Honorable Supreme Court and High Courts. And then, my lords, one, Kerala High Court is cited. Number 2, my lords, over the page, my lord, a Bombay High Court judgment is cited. Number 3, my lord, there is a Madras High Court judgment which is cited. And see the last paragraph, my lord, on this page. And this is what I was talking about, my lord. This is not as innocuous as the learned AG says, oh, we have not done anything. We have left it to the local committees. As mentioned in the aforementioned rulings of the Honorable Supreme Court and various High Court, since the prohibition of a headscarf or a garment covering the head is not a violation of Article 25. Additionally, in terms of the Karnataka Education Act, the government has decreed as below. Then, my lords, over the page, this is the order. This is as far as schools are concerned.
That order is what is binding
my lord,
upon authorities.
My lord, I don't understand, my lord, this kind of anxiety by the learned AG. We are, my lords, making submissions. We are not on the street. I respect the AG immensely, but I think at least a little bit of that modicum of respect should come back.
I am saying now that I am saying.
Lord, I am making a submission. Learned AG will not interrupt.
The operating portion of
Lord,
the
will protect me, my lord. This is not the way, my lord. The AG of a state should, my lord, argue a case. My lord, I am making a submission. Just have a look at the order, my lords. The last paragraph. In colleges that come under the pre-university education department's jurisdiction, the uniforms mandated by the College Development Committee or the Board of Management should be worn. In the event that the management does mandate a uniform, students should wear clothes that are in the interest of unity, equality, and public order. Now, my lords, by itself, my lord, it may sound innocuous, but what precedes this order is the declaration of a law which the state is entirely incompetent to, my lords, make, that hijab or wearing a headscarf is not a part of religion. And that is why, my lord, this challenge to the GO is crucial. My lord, we are not concerned, my lord, with whether the committee has the power to do it, whether, my lord,
Mr. Kamath,
yes,
we will now consider now this issue that as whether the wearing of headscarf
my lord,
confers any fundamental right
Yes, my lord.
under Article 25?
Yes, my lord. That's the heart of this case, my lord. That's the heart of this case. Your lordships have.
Now, that question would be considered by us.
Yes,
now.
my lord. Yes, my lord. But I am saying, my lord, since it's an issue of fundamental rights and lordships, my lord, as a constitutional court, my
There's
lord.
one more question which may require consideration.
Yes, my lord.
As to whether wearing of this head scarf
Yes, my lord.
is an essential part of
Absolutely,
religious
my lord.
practice.
Absolutely, my lord. My
Yes,
lords,
my lord.
Then
lords,
only
on the
comes the
interim
fundamental right.
arrangement, my lords, on the
Then
interim
only the
arrangement,
question
my
of
lord.
fundamental right. First,
Yes,
you will have to address as to
Yes,
whether it is an essential part of the
Absolutely,
religious
my lord.
practice.
My lord,
Then
there
question
is
comes
plenty.
under Article
There is
25.
plenty
I'll
that
go
I
down,
will
my lord.
place.
Lords,
There is
what I was
plenty
saying is,
that
my
I
lord,
will place.
just as in any case, my lord, for the interim, lordships will have to be satisfied, my lord, that the petitioners before your lordships have a prima facie case. There is a balance of convenience. And, my lord, a third principle of irreparable injury. And what I wish to submit, my lord, that I want to make a prima facie case.
That is why, Mr. Kamath, we
Yes, ma'am.
asked Mr. Hegde
Yes,
as
ma'am.
to whether he is taking his submission finally on the
Yes,
final
ma'am.
hearing of the matter or for the interim purpose.
My lords, I
What
was,
is the-
May I
was-
answer?
I
The
was
question is to
supposed
me.
representing he-
Mr.
that for
Kamath,
the
the question
interim-
is to me.
Yes, my lord.
The question is to me, my lords.
I have no
And,
difficulty. Let Mr.
and-
Hegde, thereafter I'll answer, my lord.
Please, my lords. My lords, I do not like my arguments being anticipated on my side.
Definitely.
Please, my lords. And here, my lords, there are two parts of the argument. There is as far, and that is why I was trying to ascertain the convenience of the court. Primarily, it is this. If we go into the question of essential religious practice, I place the Quranic verses, I place the commentaries on it, and thereafter, your lordships hears Mr. Kamath, your lordships hears the Advocate General, and it goes on. I can assure your lordships that it will take time, and it will not. And if I may use the phrase, it may take God's good time.
It will take time. You cannot.
It will take God's good time. But there are children, there are girl students who have a very difficult problem. It is very easy for the Advocate General to say, let them just go back. But should they, having taken a conscientious decision, freedom of conscience is also assured to every citizen, irrespective of majority or minority. Should they, in the interim, stifle their conscience and go back into school? Is that the piece that is? My lords, I have some experience of this state. I have been at Standing Council for 10 years. I know the problems of administering. And, my lords, there was particularly the time when Mr. Rajkumar was kidnapped, where we had Justice Bharucha in the Supreme Court handling the case. And when we told Justice Bharucha that, sir, if anything happens, there would be anarchy, he looked at us and said that if you can't rule according to the law, quit. Where I have, and my lords, thereafter, the matter went on for a long time, and ultimately it got resolved. There are some things which can wait for resolution. There are some things where before the fire comes, it has to be doused. And that is why I kept on to the smaller argument. My lords, I've also handled this state when the chief minister of the state went on a padayatra during the Kaveri time, and we had to answer an angry Supreme Court. There have been times I know where wisdom lies in not being maximalistic, where wisdom lies in trying to find a middle path which everybody can safely tread on till such time that there is a judicial resolution.
Yes.
My lords, I am reminded of how there was a huge problem in Delhi when Mandal came in. And it was the Supreme Court where Justice K.N. Singh of who had originally come from your lordship's Allahabad High Court said, it's our children who are dying there. Today, all that I am requesting the state to say is that irrespective of what kind of dress, what kind of food, what kind of faith, they are all our children. They are all our girl children. And this is not a case only about essential religious practice. It is a case of essential education for the girl child. And so if there is a state, if there is, I will prove that there is no rule. I will prove that there is no guideline on this. However, even assuming today that there is this resolution of a college committee, which reads, my lords, let me make a confession. I can't read Kannada. I'm reading Kannada from the Roman script, but I can speak Kannada. And
I can neither read nor speak.
Yes. Therefore, my lords, the college requirement is ಬಿಳಿ ಬಣ್ಣ ಮತ್ತು ನೀಲಿ ಬಣ್ಣದ ಚೆಕ್ ಸ್ಟಾಪ್ ಮತ್ತು ನೀಲಿ ಬಣ್ಣದ ಪ್ಯಾಂಟಿನ ಕಲರಿನ ಭುಜದ ಮೇಲೆ ಹಾಕಿ ಕೊಡುವ ಶಾಲ್, which basically means the same color as the pants, as the chudidar or the shalwar. You will have a shawl or a dupatta on your shoulders. Students, my girl children, will adhere to that. If they tuck that same chudidar over their head, nobody should, consistent with their faith, nobody should have an objection. And particularly, my lords, I showed your lordships the pleadings. This is something which can be resolved at that PUC college level. A wise administration, a wise government will issue the necessary instructions. Today, your lordships may consider it. If your lordships gives a clarification that those children can go back to school, they will be wearing the uniform. How they wear the uniform or a part of the uniform consistent with their faith is up to them. Nobody should have any objection whatsoever. That is one way of sorting it out. That is one way of sorting it out in the interim. And that's the course of wisdom, even if it is I who says so. There are very deep-seated questions of identity here. Is it essential religious belief? I heard the Advocate General yesterday say that there are 2 verses of the Quran and there are multiple interpretations. To which my most respectful answer is, my lords, that it is my religious faith as a lawyer of this court that the Constitution of India is supreme. And there may be one article here and one article there. There may be a 14 here, there may be a 21 there. There may be multiple interpretations of what 14 and 21 are. But there can be no manner of doubt that they all come to the aid of every citizen, for the butcher and the baker and the candlestick maker, to use Justice Vivian Bose's quotation from The Owl and the Pussycat. So here, my lords, I do not wish to add any fuel to any fire. The first thing that this state needs is for the children to return to school, for peace to return, and the atmosphere of tenseness to calm down. This is a state which cannot afford any kind of disturbance. This is the state which contributes the maximum to India. I was very proud when I used to represent it in the Supreme Court to say that we probably provide more in income tax than per capita than almost any other state in India. This is a state which has contributed the maximum unicorns to the Indian economy. I would not want it imperiled. And if a problem can be confined to a small place in an easy manner, I would request your lordships, in your wisdom, to suggest to the state and to work out something. My lords, it does not, leaving it to the college development committee would, I agree with Mr. Kamath there, would not be healthy. The college development committee, the local MLA, everybody has their own calculus. I'm not saying right, wrong, or the other. They may not see the big picture. They may not have had the benefit of working so much on the law over so many years. Today, my lords, if the Advocate General of the state could be asked to do something that in a manner consistent with the dignity of everyone. After all, what is the preamble of the Constitution? What is it? After everything it says, consistent with the liberty and dignity of the individual. This is a question of a woman's perceived sense of identity and dignity. Of a girl child who, like in my hometown of Udupi, we had Kanakadasa, who was excluded from the Udupi Sri Krishna temple. We had the father of the Constitution, Dr. Ambedkar, when he went to school, was told to sit slightly apart on a sackcloth apart from his students. After so many years of the Constitution, after so many years of the Republic, my lords, I do not want any kind of separation. We are a country which is like no other. We are a mix of so many influences, so many kinds of people. I explained things to my brother's mother-in-law, who's a white American, that there is one operating principle in India, which if you know, everything works. And she asked, what is that? I said, sometimes we have to kindly adjust. That one word, that adjust, kindly adjust. Well, Lords, that is reflected in the last words of the Supreme Court of Justice Chinnappa Reddy's judgment of the Supreme Court in Bijoy Emanuel, my lords. My lords, Bijoy Emanuel, the last line, if your lordship just gives me a minute. Is that we only wish to add, our tradition teaches tolerance, our philosophy teaches tolerance, our constitution practices tolerance. Let us not dilute it. My lords, if the learned Advocate General could be asked that is there some way, and I am willing to sit with the learned Advocate General at whatever personal cost or whatever, to sort things out. But if your lordships could ask the state, why do we stake unnecessary pride or whatever on, why do we stake our country on some one particular version, that this and this alone is the path? My lords, we are a country, we are a civilization of multiple paths.
My lords, if my learned friend has finished, then only I'll start. Yeah. My lord, I completely subscribe, my lords, to what my learned friend has, submitted. My lord, this suggestion had also come, my lord, from the bench when my lord's Honorable Justice Dixit was there, and this was put to the learned Advocate General. Learned Advocate General, my lords, frankly said that, my lord, nothing may be possible. And thereafter, my lord, lordship started the hearing. Even at this stage, my lord, if the learned Advocate General says something can be worked out, that, my lord, we continue to go to school wearing only our headscarf with the same color, my lord, we would be too happy, my lord, and the lordships can decide this matter, my lord, in the fullness of time. But if that is not a, my lord, possibility, then I would urge your lordships to kindly hear us, my lord, on the prima facie case, balance of convenience, and just give me, my lords, 15-20 minutes. I will show, my lord, that this whole geo is nothing but a sham, my lord. I can show that, my lord, in just 10 minutes. And my lord, lordships may ask the AG if something is possible. I will not argue, my lord. There's no difficulty at all. But we would all like, my lords, that the matter can be resolved at least at the interim stage without, my lords, having to trouble your lordships. But if that is not possible, my lord, I respectfully submit, my lord, that lordships will hear us on the interim relief. That's all, my lord, at this stage.
In continuation with Mr. Kamath has submitted a very short submission in support of the petitioners. But this was suggested before His Lordship Mr. Dixit also. I may request, but this is more a question of attitude, at least for this interim statement. Of course, we can be rather argue for days and days together. All that I am submitting, if there is a correct attitude on this, if there is a correct attitude, the state is actually winning, not losing. But when
Are you representing anyone?
I am, my lord, in writ petition civil number 2347/2022, where I made a submission before His Lordship Justice Dixit also. His Lordship was pleased to entertain the submission. Probably I am in continuation with that. IA number 7 is the IM. I am only on a very short issue. I am not arguing the matter. I am only suggesting 1 minute will be enough. What I am suggesting is this. But if the state is benevolent enough to understand the situation and to take an interim measure to entertain these students with the dress, with the attire, because why I am submitting, your lordship knows, but we have a constitution which says 25 explanation says, but even the kirpal is permitted. But this was the submission which I was trying to make before the Justice Dixit also, kirpal. And there is a Punjab and Haryana High Court judgment. Despite the inherent danger with a kirpal may pose, this is the constitution which has accepted that. There's a Punjab and Haryana judgment on that. There's also a judgment of a foreign court. All that I submit. If they feel that this is harmless, this is not that harmful. If the dress, if the attire is not that harmful, they can take a view on this. And that's what I'm saying.
The student of University of Oxford, and is not a party to the proceedings, not a petitioner, etc. Therefore, this application now they have filed to intervene in the matter as an impleading applicant in this petition. Obviously, they have no locus onwards as a party. So if Mother and Friend wants to implead himself, then an application has to file. We'll file our statement of objections. Only then, after impleading process may hear, we'll have one. Because this will become very difficult for number of impleading applications, subject to what ultimately launch.
Lord, sir. So therefore,
but I do not know how.
So there doesn't seem to be much of a consensus, my lord, on an interim arrangement. So we will not waste your lordship's precious time, my lord. Just give me 20 minutes, my lord. I will demonstrate, my lord, a prima facie case for grant of an interim order, my lord. Just have a look at, my lord.
Without interruption, my lord, the one IA which the learned AG was referring to is in fact IA number 6 of 2020. I think the AG is slightly getting confused between the two IAs. There are two interlocutory applications filed. One is by a Oxford University PhD student who is working and researching on discrimination.
That's all right, ma'am. That's all right, madam.
Yes,
let's go on merits.
Yes.
My lords, may kindly, my lord, just bear with me, lordships. I have heard Mr. Hegde, my lord.
No,
just
I have not completed.
Just give me 15-20 minutes, my lord, on prima facie case. And my lord, thereafter, my lord, lordships will take a call because it's already 3:45, my lord. Lord, just give me 15-20 minutes.
I had not completed.
Yes, my lord. Lord, just give me 15-20 minutes, my lord. On prima facie case, my learned friend has argued on the law.
Our request is that all should argue one by one.
Yes, my lord.
We cannot hear the arguments in piecemeals.
Yes, I follow that, my lord. Hearing us on interim, my learned friend stopped, my lord. That's why
then only you argue.
Yes, my learned friend
I yielded to the Advocate General who has a right of audience.
Correct.
Otherwise, the normal rule is that the court hears one petition after the other.
Very well.
And so, since I was placing the first petition, my lords, even on the prima facie a case, my lords, if your lordship comes back to my written submissions,
Yes.
because that will also make out my case on prima facie. My written submissions were in a separate volume. Your lordship has.
Yes. There is the memo.
Please, ma'am. The petitioners are Indian women who have been denied access to classroom education. This is on the sole ground that they chose to wear a hijab. The petitioners contend that the actions of the state and colleges are illegal, as the Karnataka Education Act and the rules made thereunder do not prescribe a uniform. Even assuming that a uniform is mandated, there is no punishment prescribed for failure to wear a uniform. The right to wear a hijab falls within the ambit of the right of expression guaranteed by Article 19(1)(a), the right to privacy, and also the freedom of conscience under Article 25 of the Constitution. The same cannot be infringed upon without a valid within court law. My lords, I have the background for this is the preliminary submission on constitutional avoidance, where the Supreme Court following.
Mr. Hegde, we have understood Karnataka Education Act do not prescribe a uniform.
Please,
There is no punishment prescribed for failure to wear a uniform.
Please,
now, so far as this submission, right to wear a hijab falls within the ambit of the right of expression guaranteed under Article 19(1)(a), and the right to privacy and also freedom of conscience under Article 25 is concerned. Do you want to elaborate?
My lords, there is an elaborate written submission in there. But my request today is simply this, that the normal rule of constitutional adjudication is that if your lordships can dispose it off on a smaller question without going in to the larger question of the hijab, then your lordships will go there. It will necessarily go use that, and that is what the Supreme Court has held. If your lordship sees at page 2, I am of the opinion that a case which can be decided of without deciding constitutional questions should be so determined without expressing an opinion on the constitutional questions raised, unless absolutely necessary for the purpose of deciding the case. I do not think.
Please. That stage is not now, because already the learned single judge has said that these issues now involve important constitutional issues which require to be determined by the larger bench.
Please.
So now you are before the larger bench. So
Please.
now these are the constitutional issues which are required to be considered. So we cannot say that without referring to the constitutional issues, we can decide the matter now.
Please, ma'am.
What we feel is that stage is now over.
Please, my lords.
The matter has come up before the larger bench.
The second submission. Please, my lords. My lords, may I request my learned friend, Mr. Tahir, to give the second set of submissions on the larger issue. I had separately put it in two separate headings, one on the smaller issue, one on the larger issue. Mr. Tahir, I can't make out whether he's in the courtroom. I'm sorry. I'll wait. Yes, my lord, got it.
Yes.
Please, my lords. In the Court and National Legal Services Authority, 2014 5 SCC 438 has recognized that clothing and appearance fall within the ambit of the right of expression guaranteed under Article 19(1)(a) of the Constitution. In Jigya Yadav versus CBSE 2021 7 SCC, the court was dealing with CBSE bylaws that restricted a student from changing his name in the records. So, para 125 thereof, I've put in all the passages for ease. Identity, therefore, is an amalgam of various internal and external, including acquired characteristics of an individual, and name can be regarded as one of the foremost indicators of identity. And therefore, an individual must be in complete control of her name, and law must enable her to retain as well as to exercise such control freely for all times. Such control would inevitably include the aspiration of an individual to be recognized by a different name for a just cause. 19(1)(a) of the Constitution provides for a guaranteed right of freedom of speech. In the light of Navtej Johar, this freedom would include the freedom to lawfully express one's identity in the manner of their liking. In other words, expression of identity is a protected element of freedom of expression under the Constitution. In this case, wearing of a hijab is an expression of religious identity. The same is a right protected under 19(1)(a) of the Constitution. It can only be curtailed by way of reasonable restrictions under the grounds mentioned in 19(2). None of the grounds are made out in this case. It's also relevant to submit that the state has a positive obligation on the state to create and maintain conditions in which the freedoms guaranteed by the Constitution can be exercised. In the state of West Bengal case, the court held the freedoms which are guaranteed by 19 are universal. 19(1)(a) stipulates that all citizens shall have the freedoms which it recognizes. Political freedoms impose a restraining influence on the state by carving out an area in which the state shall not interfere. Hence, these freedoms are perceived to impose obligations of a restraint on the state. But apart from imposing negative restraints on the state, these freedoms impose a positive mandate as well. In its capacity as a public authority enforcing the rule of law, the state must ensure that conditions in which those freedoms flourish are maintained. In the space reserved for the free exercise of speech and expression, the state cannot look askance when organized interests threaten the existence of freedom. The state is duty-bound to ensure the prevalence of conditions in which those freedoms can be exercised. The instruments of the state must be utilized to effectuate the exercise of freedom. When organized interests threaten the properties of theater owners or the viewing audience with reprisals, it is the plain duty of the state to ensure that speech is not silenced by fear of the mob. Unless we were to read a positive obligation on the state to create and maintain conditions in which freedoms guaranteed by the Constitution can be exercised, there is a real danger that art and literature would become victims of intolerance. In the present case, we are of the view there has been an unconstitutional attempt to invade the fundamental rights of the producers, the actors, and the audience. My lords, then, if I may skip over the rest of that passage, if your lordship permits the next one, the right to privacy, the freedom of conscience, and the right to practice, profess, and propagate religion are explicitly recognized under Article 25. The Supreme Court also recognized the freedom of conscience to be part of the right of privacy. In Puttaswamy, the court observed, while the right to freely, this is para 372, while the right to freely profess, practice, and propagate religion may be a facet of free speech guaranteed under 19(1)(a), The freedom of the belief or faith in any religion is a matter of conscience falling within the zone of purely private thought process and is an aspect of liberty. In the specific context of appearance and clothing, the court observed, the choice of appearance and apparel are also aspects of the right of privacy. The freedom of certain groups of subjects to determine their appearance and apparel, such as keeping long hair and wearing a turban, are protected not as a part of the right of privacy, but as a part of their religious belief. Such a freedom need not be necessarily based on religious beliefs following under Article 35. These are from the opinion of Justice Chelameshwar. Once it is established that the freedom of conscience forms a part of the right of privacy, any infringement thereof has to be tested on the touchstone of the triple test laid down in Puttaswamy at paragraph 310 and reiterated in the 5-judge judgment of Puttaswamy. To constitute a valid infringement of privacy, there must be A, an existence of a law. And that's why in my earlier submission that there is no law. B, a legitimate state interest. C, that the law must be proportionate. In this case, neither the 1983 Act nor the 95 rules prescribe a uniform or prohibit the wearing of a hijab. Thus, the first requisite, that is the existence of a law, is not met. My lords, then my submissions under 25 are that 25 of the Constitution confers two distinct fundamental rights. One is the freedom of conscience. Second is the free profession, practice, and propagation of a religion. The right under Article 25 is made subject to public order, morality, health, and other fundamental rights. Article 25 rights are conferred upon communities as well as individuals. The vast majority of cases adjudicated by constitutional courts deal with the second aspect of 25, that is free profession and practice and propagation of religion. These cases have broadly involved the determination of practices that can be understood as a group or community practice. This court, the Supreme Court has held that only an essential religious practice is protected under Article 25. My lords, while arguing before Justice Dikshit, I mentioned that too was a great case which came out of the same town of Udupi, my hometown. That was in the Shirur Mutt case, where the Supreme Court first said, it propounded that yes, what is protected under Article 25 is the essential religious practice. In this case, the petitioners claim the right to wear hijabs on the basis of their individual freedom of conscience as well as on their right of religion. The lead judgment on the freedom of conscience is Biju Emmanuel, which is 86.3 SCC, which dealt with the issue without going into the question of essential religious practice. It ultimately held that we are satisfied. My lords, may I request here that your lordship kindly turn to the judgment of Biju Emmanuel itself, which is there in the compilation, which may have been handed over to your lordships. 203. I do it for a particular purpose, because the facts in Biju Emmanuel are strangely somewhat like the facts of what happened here. At 207, my lords, of the compilation.
203.
It starts at 203 and is at 207. The three child appellants, Biju, Binumol, and Bindu Emmanuel, are faithful of Jehovah's Witnesses. They attend school. During the morning assembly, when the national anthem is sung, they stand respectfully, but they do not sing. They do not sing because according to them, it is against the tenets of their religious faith. Not the words or the thoughts of the anthem, but the singing of it. This day, and before them, their elder sisters who attended the same school earlier have done all these several years. No one bothered, no one worried, no one thought it disrespectful or unpatriotic. The children were left in peace and to their beliefs. This was until July 1985 when some patriotic gentleman took notice. The gentleman thought it was unpatriotic of the children not to sing the national anthem. He happened to be a member of the Legislative Assembly. My lords, I read my pleadings, and here also, my lords, ultimately constitutional rights, constitutional beliefs cannot necessarily be led to the adjudication of politicians, whether they happen to be members of parliament or members of the Legislative Assembly. Ultimately, it is the Constitution that protects all citizens, irrespective of whether they happen to be in power or out of power, elected or unelected. My lords, after these facts, if your lordships, before I've placed that conclusion at page at paragraph 25, but there I would also want to place before your lordships para 90, which I think is important. Para 19 is at page 214. May I read, my lords? Yes, my lords. Yes. I have all my lords got it, please. Para 19. We see that the right to freedom of conscience and freely to profess, practice, and propagate religion guaranteed by Article 25 is subject to public order, morality, and health, other provisions of Part 3 of the Constitution. Any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice, or B, providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all sections and classes of Hindus. Thus, while on the one hand, Article 25(1) expressly subjects the rights guaranteed by it to public order, morality, and health, and to the other provisions of Part 3 on the other hand, the state is given the liberty to make a law to regulate or restrict economic, financial, political, or other secular activity which may be associated with religious practice, and to provide for social welfare and reform, even if such regulation, restriction, or provision affects the right guaranteed to them by 25(1). Therefore, whenever the fundamental right to freedom of conscience and to profess, practice, and propagate religion is invoked, the act complained of as offending the fundamental right must be examined to discover whether such act is to protect public order, morality, and health, whether it is to give effect to other provisions of Part 3, or whether it is authorized by a law made to regulate or restrict any economic, financial, political, or secular activity which may be associated with religious practice, or to provide for social welfare and reforms. It's the duty and function to do so. Here again, as mentioned in connection with Articles 19(2) to 6, it must be a law having force of a statute and not a mere executive or a departmental instruction. Here, my lords, Shirur Mutt is quoted. The portion from Lathan, and then what is religion is also quoted, my lords, at paragraph 20, and my lords, there is also one passage at para 22, which probably reflects what the dilemmas that the Advocate General and the government are facing. In the middle of para 22, Justice Jackson referred to Lincoln's famous dilemma. Must a government of necessity be too, and the emphasis on strong, for the liberties of its people, or too weak to maintain its own existence? And added, it may be doubted whether Mr. Lincoln would have thought that the strength of government to maintain itself would be impressively vindicated by our confirming power of the state to expel a handful of children from school. Such oversimplification, so handy in political debate, often lacks the precision necessary to postulates of judicial reasoning. If validly applied to this problem, the utterance cited would resolve every issue of power in favor of those in authority and require us to override every liberty thought to weaken or delay execution of their policies. Governments of limited power need not be anemic government. Assurance that rights are secure tends to diminish fear and jealousy of strong government, and by making us feel safe to live under it, makes for its better support. Without promise of a limiting Bill of Rights, it is doubtful if our Constitution could have mustered enough strength to enable its ratification. To enforce those rights today is not to choose weak government over strong government. It is only to adhere as a means of strength to individual freedom of mind in preference to officially disciplined uniformity, for which history indicates a disappointing and disastrous end. Justice Jackson ended, further below, Justice Jackson ended his opinion with the statement, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. We think the action of local authorities in compelling the flag salute and pledge transcends constitutional limitations on their power and invades the sphere of the intellect and the spirit, which is the purpose of the First Amendment to our Constitution, to reserve from all official control. And so, thereafter, I've already placed para 25, my lords, and that last sentence at para 27. So, my lords, now my comment at para 10 of my written submission. It is clear from the above that the issue as formulated by the court was not whether refusal to sing the national anthem was an essential religious practice to Jehovah's Witness. Rather, the issue was whether the person claiming a religious exemption was doing it on the basis of their bona fide faith. My lords, then assuming that the essential religious practice test applies, the wearing of a hijab is essential to the Islamic faith as far as women are concerned. And the High Court judgments have been set out, my lords. The first is the 2015 judgment, where the single judge observed, it cannot be ignored that in our country, with its varied and diverse religions and customs, it cannot be insisted that a particular dress code be followed, failing which a student will be prohibited from sitting for the exams. It directed that at the two centers indicated in the writ petition, the invigilator, along with a woman invigilator or other authorized officer, shall be present half an hour before the examination commences. The petitioner who intends to wear a dress according to their religious custom, but contrary to the dress code, shall present themselves before the invigilator half an hour before the exam, and on any suspicion being expressed by the invigilator, shall subject themselves to any acceptable mode of personal examination as decided by the invigilator, but however carried on by an authorized person of the same sex. If the invigilator removes the headscarf or full sleeve garments to be removed and examined, the petitioners shall subject themselves to that by an authorized person. It's desirable that the CBSE issues general instructions. It came up again before another single judge, and Justice Mohammad Mushtaq, my lords, considered the place of hijab under Islamic law. And in paragraphs 20 to 29, my lord, since it has placed extensively by Mr. Kamath, I've not, and then at para 30, the discussions as above would show that covering the head and wearing a long sleeve dress by women has been treated as an essential part of the Islamic religion. It follows a fortiori that Article 25(1) protects such. Please, please, my lords. And then there was a balancing done by the court at para 36. The court, taking note of the practical difficulty of the board for the conduct of the exam, provided sufficient safeguards. The court was of the view that the same can be followed for this year as well, and board can take necessary steps for the next year onwards while inviting applications itself to protect such rights. It is to be noted, practical difficulty cannot be an excuse to dishonor the fundamental rights. Therefore, this court is of the view that for this year, the board shall permit all candidates who, based on religious practice, want to wear the headscarf and full sleeve and dress to appear for the exam. This court need not interfere with the dress code prescription as referred in the prospectus, as others are bound by such prescription, except to hold that the dress code as above shall not be enforced against the candidates who, by virtue of Article 25, are protected from wearing such dress as prescribed in the injunctions of their faith. The writ petitions were accordingly allowed. The CBSE appealed the decision to a division bench. However, by the time the matter was heard, the CBSE had issued a notification. Besides, para 15, my lords, besides the fact that the wearing of hijab has been found to be an essential religious practice, one other aspect is of the court in those cases was dealing with a temporary prohibition. My lords, the temporary prohibition was that during exams, do not wear the hijab. Because sometimes these days with modern technology, with Bluetooth, with whatnot, a hijab might be useful. For that purpose alone, even there where there was a prescription, the court said, okay, this is how we balance it out. Come half an hour earlier, make arrangements so that if anybody wants to check you with it, it can be done. The other judgment that the learned advocate general had also pointed out was, my lords, I have stated in paragraph 16, but that, however, was a private school and perhaps also a Christian minority institution. And when the balancing happened there in para 17, the petitioners cannot seek imposition of their individual right as against the larger right of the institution. It is for the institution to decide whether the petitioners can be permitted to attend the classes with the headscarf and full sleeve shirt. It is purely within the domain of the institution to decide. The court cannot direct the institution to consider such a request. This judgment may, if I were to distinguish on facts, private institution, minority institution, and the court was balancing two fundamental rights. As against this, in the facts of our case, this is a government institution which belongs to every citizen, or every inhabitant of Karnataka to every citizen of India. There are all kinds of inhabitants, there are all kinds of citizens. Now, can you, by a rule, make for a set of citizens or inhabitants that you may have to forsake an essential tenet of your faith at the time that you attend the institution? If you say that, then where is the overweening state interest that this alone will be done? That you will attend in this manner alone and in no other manner? Where does it satisfy the triple test which has been laid down in Puttaswamy? There is nothing. And therefore, what your lordships is called upon, even at the interim stage, is to find the right balance.
Yes.
And as has been submitted, my lords, here there's a prima facie case. There is also the balance of convenience in my favor, that denial of the right to attend the college would have irreversible consequences. I would implore my lords, not only as far as the education of these children are concerned, everybody, in the interest of everybody's education, to find the right balance. And before I go, one thing I wanted to point out, that there are specific provisions in various central enactments which actually permit face coverings. If your lordship sees section 129 of the Motor Vehicles Act, there, I'm sorry, it's not for face covering. It's not for face covering. 129 of the Motor Vehicles Act provides that the provision shall not apply to a person who is a Sikh if he is, while driving or riding on the motorcycle, wearing a turban. So you don't need a helmet. Similarly, in the Supreme Court rules, there are rules specifically made for the benefit of Pardanash in women. Order 9, Rule 8, which says that where the deponent is a Pardanashi lady, she shall affirm or take oath before a lady registrar of the court, which shall include an additional registrar duly authorized. So the provisions, there are provisions which specifically authorize. Today, the provisions do not specifically take away, but in practice are being so implemented in this institution so as to effectively render it nugatory. It could be clarified to the institution. If the Advocate General says that it can be done on the state aspect, your lordships may consider the weight of it. Otherwise, your lordships would be required to pass interim orders, my lords. And I submit that in this case, there should be interim orders which would protect the right of these students. So, and particularly so, as far as these petitioners are concerned, it's a question of 2 or 3 more months of attendance. My lords, I'm very grateful for a very patient hearing, my lords.
Thank you.
May it please, my lord. My lords, I beg to appear, my lord, in WP 2880 of 2022. And I will be very brief, my lord. And I will concise, my lord, my arguments only for the purposes of, my lord, interim relief, which your lordships may kindly consider.
The appearing in 2347.
No, my lords, 2880 of 2022, Miss Aishat Shifa versus State, my lord. My lord, I will not trouble your lordships with the facts. My learned friend, my lord, has taken your lordships through some of the facts which arose in his case. But the only fact which I want to mention, my lord, which we have said in our writ petition, is that these are students, my lord, who were wearing a headscarf and going to college for the last 2 years. They are, my lords, 12th standard students. For the last 2 years, my lord, they were wearing a headscarf and going to college. Till, my lords, 3rd of February, they were stopped and said that unless you remove the headscarf, you cannot go in. Lords, apart from those facts, my lords, I don't want to trouble your lordships with the facts. My lords, my case for an interim relief today is based on 3, my lords, broad considerations. Number 1, my lords, I want to satisfy your lordships that this GO which has been issued on 5th of February 2022, firstly, my lord, suffers from a total non-application of mind. And I'll just make that good, my lord, by taking your lordships to the GO, and that will be my first ground, my lord. The second ground, my lord, I want to say that wearing a headscarf, my lord.
This government order is
Yes, my
of
lord. Yes, my lord. I'm grateful, my lord. My lords may kindly just have
translation which you had.
That's right, my lord. That's right. The Kannada version is there in the writ petition, my lord, at page 20. Yes, my lord. If I can just, my lord, place the GO itself, my lord, kindly turn to page 2, which I had just read, my lord, in my opening. The paragraph 3, the question relating to a uniform dress code over individual dressing choices has come up in several cases before the Honorable Supreme Court and High Court. And my lord, 3 decisions are cited, 1, 2, and 3 over the page, and a conclusion is drawn. Kindly see the next page, my lord. The conclusion is drawn that these 3 judgments say that hijab or a headscarf is not a part of Article 25. And that, my lord, I respectfully submit, is a result of a total non-application of mine, because these 3 judgments don't say that at all. Lord, the entire basis of this GO is high courts have held that this hijab is not a part of Article 25. And I'll prima facie demonstrate, my lord, that this is not so. If your lordships can have the compilation which I had, my lord, given to the Honorable Court. My lords, this is a compilation, my lord. I request Shaul to kindly hand over the compilation to volume 1 to the Honorable Court. And I'll show, my lord, all these 3 decisions are totally, my lords, against the state. Just, my lord, if I can just place those decisions quickly, my lord. If my learned friend can just hand it over to the court master to give it to the Honorable Court. Volume 1, yes.
It is their understanding what you have to say on that. It is their understanding which they have.
Yes, my lord. That's right, my lord. I am saying, my lord, I am saying that understanding is totally incorrect, my lord. That's for your lordships to, my lords, lord, decide. And I'll show that, my lord.
Thing is that come to the operative portion of the government order.
Yes, my lord. I am saying
how it affects. How
the reason is this. If the decision, my lord, at the penultimate paragraph, that, my lord, there is no prohibition of, my lord, Article 25 as far as wearing a headscarf is concerned. If that goes, my lord, this is totally innocuous. This is, my lord, you deal a body blow.
It is come to the operative portion. What
I go down, my lord. I am saying, my lord,
the institutions or the persons on whom this is binding, they have to go by the operative portion of the government order.
But they will also be guided.
The government order says.
Yes, my lord. I am extremely grateful for that question, my lord. They will also be guided.
That may be the foundation for this.
Yes.
That all those what have been earlier said.
Yes.
It may not have been said.
Lordships may.
It is a foundation for this. Yeah. Whatever the operative portion says.
Yes, my lord. But ultimately, the building is built on the foundation, my lord. The foundation is this. Foundation is that prohibition of headscarf is not a violation of Article 25. And it's an enabling provision, my lord, for the colleges to now say, and which they are saying, my lord, that look here, you can't wear a headscarf. I am saying if the foundation goes, my lord, the building can't stand. So therefore, my lord, the foundation itself is totally questionable, is what I am saying. Now kindly see these 3 judgments, my lord, which the state relies upon. And then, my lord, I'll just make that good. The first judgment, my lord, which the state relies upon, is, my lord, a ruling of a writ petition 35923. My lords, that your lordships will please find at page 39 of this compilation.
39.
Yes, my lord.
Yes.
Totally, my lords, inapplicable to the facts of this case. Just have a look at page 39. Religious dress. I'm sorry, my lord.
Yes.
My lord has page 39, my lord.
Yes, page 39 of your compilation.
Yes, my lord. Religious dress in a private educational institution is an issue in this writ petition. My lord, the Chief Justice got it.
No, the compilation which you have passed on. This
Lord, page 39, this compilation, my lord, it starts with Fatima Hussain, my lord.
It is not on this.
Lord, I don't know. Volume 1, which we handed over to the Honorable Learned Single Judge, my lord.
Which has been given to us is volume 2.
No, volume 1. I'm sorry, I think they have made a mistake, my lord. I'm so sorry, my lord. Volume 1, I was requesting. I'm so sorry, my lord, to waste the lordship's time. I'm so sorry, my lord. My apologies.
Yes.
Lord, sir, since it is virtual, my lord, we are unable to, my lord, properly assist your lordships, my lord, whether it is, my lord,
it is not virtual.
It
is not virtual. We are in a hybrid mode.
Yes, my lord. I'm sorry, my lord, since I am addressing yes, my lord, since I am addressing your lordships, yes, my lord, I am at a handicap, my lord. That's why I'm not assisting your lordships, my lord. Lords may kindly have page 35.
No choice that you are appearing by virtual mode.
Yes, my lord. Lords, page 39, my lord, of this. If your lordships may kindly see. Yes, my lord. Yes, my lord. This is the first decision which is cited in the GO. And kindly see, my lord, what is the issue here? Religious dress in a private educational institution is an issue in this writ petition, not a government college, my lord. Then, my lords, kindly turn over the page. I just invite lordship's attention to paragraph 4, what the learned single judge says. The court
what has been held in this judgment?
Yes.
What has been held in this judgment?
Lords, what the court says, my lord, that ultimately, my lord, a private minority educational institution cannot be forced, my lords. Yes, my lord. Yes, straight away, my lord. My lords, may I just place that straight away, my lord? My lords, may kindly first turn to paragraph 4. This first paragraph 3, my lord. One has the liberty to follow his own notions and convictions in the matter of dress code. At the same time, when such a right is claimed against a private entity, kindly see this, my lord, which is also having equal fundamental right to manage and administer an institution, this court has to balance competing fundamental rights and decide the issue. Now see paragraph 4, my lord. This issue, this court by judgment in Anna bint Bashir versus CBSE had taken a view that a right of a woman to have the choice of dress based on religious injunctions is a fundamental right protected under Article 25 when such prescription of dress is an essential part of religion. Therefore, there may not be any difficulty to hold that it is the fundamental right of the petitioners to choose the dress of their own choice. Then, my lords, paragraph 5, my lord, that is the Article 30 right is discussed, that is of a minority institution. And then, my lord, may turn over the page. Paragraph 10, my lord, page 41.
Come to paragraph 7.
7, my lord, I'll read it, my lord. Fundamental rights are either in the nature of the absolute right or relative right. Absolute rights are non-negotiable. Relative rights are always subject to restriction imposed by the Constitution. The religious rights are relative rights. In the absence of any restriction placed by the state, the court need not examine the matter in the light of the restriction under the Constitution. The court will therefore have to examine the matter on a totally different angle on the conflict between fundamental rights available to both. The court has to examine the prioritization of fundamental rights in a larger legal principle on the legal system function in the absence of any constitutional guidance. In this regard, the Constitution itself envisages society where rights are balanced to subserve the larger interest of society. So, my lord, in the context of Article 30, the court says you have to balance the fundamental rights. So, what your lord?
They have considered this judgment.
Yes.
The larger public interest.
Yes, my lord.
While issuing this government order.
Yes, my lord.
They have to balance. They have to balance the rights of both the educational institution and the individual religious rights.
Correct, my lord.
Now, considering this judgment, what is wrong?
No, my lords. What I'm saying is this. This decision, my lords, was in the context of a private minority institution which has Article 30 right. Right, my lord? Now, the same learned judge, my lord, when it comes to a government institution, please see his approach. And that is why I just wanted to place, my lord, page 24.
We are not here to judge the approach of the judge individual.
Yes,
that is not for us to see.
No, I kindly see, my lord, what has been held, because that will probably assist
people examining. You said that they have totally non-application of mind.
Yes,
to consider these judgments.
Yes,
which have been referred in the government order.
Yes, my lord.
Now we have pointed out the paragraph 7 of this judgment to you to show that in order to balance, to subserve the larger interest of the society, they have, if you consider this government order, what wrong they have done?
I bow down, my lord. That's a very important question which your lordships is posing me. But this decision, my lord, was in the context of a private minority educational institution which has a separate set of fundamental rights, my lord, under Article 30 of the Constitution. My lord, lordships are very well aware, my lord. So therefore, this
private education institutions are also under the Constitution.
I bow down, my lord. I bow down.
Only thing is that they have got some additional right to manage the institution under Article 30.
And my lords, their right, my lord, to admit students of their choice is totally unfettered, my lord.
It does not mean that the general law will not apply to them.
I bow down, my lords. I bow down. Now, my lords, kindly see what happens in the context of a government institution. Just see, my lords, page 24, if your lordships permit, page 24. So the first decision which I showed, my lord, is in the context of a minority institution, which according to us, my lord, is totally inapplicable as far as government institutions are concerned. So that is the point of distinguishing, my lord, which I wanted to place for my lord's consideration. In the context of a government order, government institution, please see what happens at page 24, my lord. Page 24 of this very compilation.
That is where the in this CBSE examination the
that's right, my lord. Where my lord, the learned judge examines, my lord,
but this is the subsequent judgment.
Yes, my lord. The subsequent judgment, my lord, notes that the general principle which is applicable in respect of government institution will not apply to private educational institutions. And that does not, my lord, the private minority institutions, my lord, in that case, there is no discussion on, my lords, whether it is an essential religious practice or not. Now, just if your lordships have this judgment, just turn to, my lords, page 29, if your lordships don't mind, my lord, page 29. My lords, in this particular judgment, the core issue which is there before your lordships as to whether wearing a headscarf, my lord, is a part of, my lord, essential religious practice was squarely gone into, not in the other judgment, my lord, which your lordship just saw. Now see page 29, para 17. Coming back to the core issue in this writ petition about the dress code, it is to be noted that Islam embraces and encompasses guidance to human will, so and so. Then, my lords, what are the sources of Islamic law are noted. And eventually, my lord, kindly see para 24, my lord. After discussing the sources of Islamic law, including the Holy Quran, the court comes to a conclusion. My lords, in paragraph 29, my lords, I'll avoid other things. Para 29, my lord. I'm sorry, page 32. Page 32, para 29. So my time is limited, my lord. I'll just show the conclusions only. Thus, the analysis of the Quranic injunctions. My lord, the Chief Justice got para 29. Yes. Thus, the analysis of the Quranic injunctions and the hadiths would show that it is a farz to cover the head and wear the long sleeve dress except face part and exposing the body otherwise is forbidden. When farz is violated by any action opposite to farz, that action becomes forbidden. However, there is a possibility of different views or opinions, which the AG was referring to yesterday. This court is not discarding such views. The possibility of having different proposition is not a ground to deny the freedom. If such propositions have some foundation in the claim, as has been adverted below, the claim of the petitioners is well founded, even though a different view is possible. So Lords, even if a different view is possible, the court says, if, my lord, it is the believer's faith, then, my lord, the courts have to yield to it, and that flows, my lord, from the Supreme Court judgments as well. Now, my lord, ultimately the court said that this is a facet of essential part of religion. Now, my lord, the second judgment which the GO relies upon is, my lord, a decision of the Bombay High Court, which your lordships will find, my lord, in the compilation itself, which is the first judgment, my lord, in the compilation. And this judgment, my lord, it's the first one in the compilation. Page 1, my lord. Page 1, my lord. The judgment starts. And see, my lords, page 2, the conclusion. Para 7, Justice Lodha's judgment, very, my lords, beautifully put. And how it is limited, my lord. Kindly see, my lord, page 2. A girl student, para 7, my lord, page 2. Yes, yes. A girl student not wearing a headscarf or head covering studying in exclusive girls section. Kindly see this, my lord. Kindly make a note, which I am recommending for your lordship's kind consideration. A girl not wearing a headscarf or head covering in studying in exclusive girls section cannot be said to in any manner acting inconsistent with the aforesaid verse 31 or vitiating any injunction provided by the Holy Quran. So, my lord, this was in the context of an all-girls school. So, therefore, my lord, in a matter of co-education, this judgment is totally inapplicable. And I will just place 1 or 2 verses of the Holy Quran, my lord, because that is the, my lord, primary source of Muslim law as per Mullah, my lord, after this. Now, my lord, this judgment is not applicable. The third judgment, my lord, which the GO relies upon is a Madras High Court judgment. And that judgment, my lord, doesn't deal with Article 25 at all. That was a case, my lord, where the teachers were asked to wear a uniform. And, my lords, under the provisions of the Tamil Nadu Education Act, whether the teachers could wear a uniform or not, that was the issue. Not even one word, my lord, about Article 25. That judgment your lordships will find, my lords, which is at page 4, my lord. I will not trouble your lordships of this very compilation. Lordships will see that judgment, page 4. My lords, there is not even one word, my lord, in the entire judgment about wearing of a headscarf or anything about Article 25. This was about prescription of my lords, a prescription of a dress to teachers. In that context, my lords, what are the provisions? What is the contract between the teachers and the government, my lord? That was an issue. Nothing to do with Article 25. And the government says, my lord, these 3 judgments are authority to say headscarf, my lord, is not a part of essential religious practice under Article 25, which I say, my lord, is a total affront to, my lords, the freedom which is guaranteed under Article 25. Now, my lords, just on this, my lord, I just want to cite 1 or 2 things on Article 25. Because I have also prepared a brief note, my lord, which has all my submissions for the purpose of interim relief. If I can request, my lord, my learned friend to just hand over that note. Because your lordships will not be troubled, my lords, by going through this judgment and that judgment. I have quoted everything. In fact, my lord, the Honorable Justice Dixit had asked me to prepare a written note. I had prepared, my lord, for that purposes. So I have, my lords, put everything at one place. So your lordships, my lord, has the benefit of seeing everything at once, my lord. If I can just request, my lord, my learned friend to hand over that note. My lords, kindly see first page 3, my lord, of this note. What is the, my lord's, essential practice? And I'll demonstrate. We don't have to go, my lord, to any subsidiary sources of Islamic law. Just have a look at page 3, my lord. What is the relevant verse of the Holy Quran? Page 3, my lord. My lords, if I can just place for my lord's consideration, verse 24:31, which I have reproduced in paragraph 7. And tell believing women that they should lower their glances, guard their private parts, and not display their charms beyond what is acceptable to reveal. They should let their headscarves fall to cover their necklines and not reveal their charms except to their husbands, their fathers, their husbands' fathers, their sons, their husbands' sons, their brothers' sons, their sisters' sons, their women folk, their slaves, such men as attend to them who have no so and so, or children who are not aware of women's. So, my lord, the prescription of headscarf is specifically prescribed in the Holy Quran. 24:31, my lords, I am placing for my lord's consideration. And my lords, verse 59, I have quoted over the page. My lords, apart from the learned single judge, which I have shown, my lord, who has gone into this, the Kerala High Court, and has said that this is essential practice of religion, there is a division bench of the Madras High Court, my lords, which I have placed in paragraph, my lords, 12, if your lordships just sees, my lord, over the page. Paragraph 12, my lords, page 5. I have cited all these other decisions, my lord. I don't want to trouble your lordships, but just see page 5, para 12. This is Ajmal Khan, my lord, and this is there in the compilation. Lordships will see that I have given the reference to the compilation page numbers also, and I have extracted, my lord, what the relevant portion is. And if I can just, my lord, invite your lordship's attention to the relevant portion, which is highlighted in paragraph 15, it is thus seen from the reported material that, I'm sorry, my lord, the Chief Justice got it, my lord. Para 7, para 12, my lord, I'm so sorry, my lord. Para 12, my lord. Yes, my lord. Para 12, division bench, my lord, of the Madras High Court. It is thus seen from reported material that there is almost unanimity amongst Muslim scholars that parda is not essential, but covering of headscarf is obligatory, my lord. So, my lord, we have an authoritative judicial, my lord's, determination on, my lord's, Islamic law, of course, of a different high court, which for the purpose of prima facie, my lord's, case, which I am placing for my lord's consideration. Then, my lords, B.J. Emmanuel was read to your lordships in detail. I am only placing, my lord, one portion of B.J. Emmanuel, which says, my lord, that what is an essential practice, my lord, is not to be seen from my standpoint or, my lords, anybody else's third party standpoint. And, my lord, we have to see it from the, my lord's, perspective of the believer. My lords, as an officer of the court, my lord, and as an individual, I may completely disagree, my lord, that headscarf should be made, my lords, anybody should insist on a headscarf. But my opinion really doesn't matter, my lord. Because ultimately, my lords, we are talking about people's fundamental rights and are in a right-based society, my lord. To say that they will not be permitted, my lord, I respectfully feel, my lord, that in a matter of where your lordships is considering interim relief, your lordships will lean in favor of a situation, my lords, where people, my lord, can exercise their fundamental rights. In that context, my lord, kindly see page 6. The quotation, my lord, from B.J. Emmanuel. If this is the belief of the community, and it is proved undoubtedly to be the belief of the Zoroastrian community, a secular judge is bound to accept that belief, and it is not for him to sit in judgment on that belief that he has no right to interfere. And then, my lord, the highlighted portion, we do endorse the view suggested by Justice Davar that question is not whether a particular religious belief or practice appeals to our reason or sentiment, but whether the belief is genuinely and conscientiously held as a part of profession or practice of religion. I respectfully submit, my lord, at this interim stage, my lord, that there is a host of judicial, my lord, pronouncement which is available. I am not requesting your lordships to only rely upon, my lord, certain verses of the Quran. I am saying those verses of the Quran have been judicially interpreted to mean that as far as headscarf is concerned, it is, my lord, it's a part of their essential religious practice.
What we find is that we are at the end of the day. Continue arguments. We will have it on Monday. We'll have it on Monday.
Lords, I was only requesting, my lord.
Thing is that we will request.
Yes, my lord.
We'll not only request, we will pass an order.
Yes, my lord.
That let the institutions start.
Yes, my lord.
Direct that institution shall start, but till the matter is pending and consideration before the court, these students and all the stakeholders, they shall not insist for wearing any religious endowment, maybe a headdress or a saffron fatwa or anything, that we will restrain everyone, because we want the peace and tranquility in the state.
Lord,
we maintain, and only then after the matter is before the court, we are now seized with the matter. We can continue the hearing on day-to-day basis also, and we are ready to decide the issues at the earliest. But the thing is that the peace and tranquility must be restored to the state.
Lord, so may I answer that?
This is what we find, that till the disposal of the matters, you people should not insist for wearing all these religious things which are not conducive
to
the
may I submit, my lord?
I am required to wear a dupatta. I am required to wear a dupatta. How they wear it?
Yes,
let them not object.
May I just respond to that, my lord? Now, what your lordships are saying, my lord, as an officer of the court, my lord, I respectfully submit, my lord, that would amount to a suspension, my lord, of Article 25 as far as the students are concerned.
Whatever it is, you may take it. But the thing is that if you want us to decide these issues,
yes,
which also find it of some constitutional importance,
yes, my lord, yes, my lord,
then you will have to cooperate.
Lords,
you will have to cooperate.
Lords, my cooperation, lords, kindly see, my lord, we are being asked to choose between food and water. My lords, kindly see, both are essential.
No, it is not a matter of.
Please don't, my lords, please don't, my lord, mistake us. We are asked to choose between education and our conscience. Please don't, my lord. I respectfully submit. My lord, these are matters of moment. This is not
you have approached the court. You have a faith on the court. Let them
absolutely, my lord. There is no doubt about
it. Then wait for some time.
Yes,
wait for some time.
Lords, I am just saying, my lords. I am just saying, my lord. Your lordships are completely, my lord. We are in the lordship.
Yes, we will pass the order.
As far as interim orders are concerned, kindly note my submissions, my lord.
We are in the midst of the arguments. We will hear you on the interim order.
I bow down, my lord. I bow down, my lord. Lords, kindly note my submission that if your lordships, my lord, direct that these students have to go without their headscarf, my lord, that would be a total affront to their rights, because your lordships have not determined whether they have a right or not. Today I have demonstrated.
It is a matter of few days only, Mr. Kamath. Please try to understand the situation.
Yes,
it is a matter of few days only.
My lord,
with respect, my lord, the state. Maybe restored for a few days.
Yes, my lord.
My lord, that's the problem. A few days,
just 10 seconds.
I can't suspend my faith.
Yes. My lord, just 10 seconds, then lordships may kindly record.
What we find, all right, we will pass the order. We are not asking for you to
may pass the order, but please record my lord's objection that this kind of an order, my lord, at this stage cannot be passed. But if you record my objection, that's my only submission, my lord.
Lord, may I
record my objection? We have given you our mind. That since we are assist with the matter, we will restrain everyone from adopting all these practices.
Yes.
My lord, may I make one request, my lords? I appear for the petitioner in WP 2347, my lords.
We will hear everyone on the next date.
Yeah, one submission, my lord. So one more writ petition is connected with my lord, that has to be connected. 3148 of 2022.
Just a minute, somebody is speaking, we cannot hear.
एक कौन सा भी जजमेंट दोनों को इनमें नहीं हो जाएगा, पूरा सब एक्सप्लोर हो जाएगा। प्लीज एनएपी डिवाइडिंग रूल पॉलिसी पॉलिटिशियन का पैसा हो गया है, अब हिंदू मुस्लिम का डराटा ज्यादा हो जाएगा। इसके लिए एक मीडिएशन हम लोग को भेजिए, नहीं तो वी विल डू द कॉम्प्रोमाइज। आई वांट द पॉलिटिशियंस, इवन मोदी साहब इतना बोल रहे हैं, मैं इतना किया करती, क्यों नहीं आ सकते डॉन में आके सबको कॉम्प्रोमाइज क्यों नहीं कर सकते? एक लड़की का सब
ऑलराइट
अगर वो मरेगा तो किसी कैन गेट सुसाइड, मरेगी मैं नहीं पहन के आएगी, ऐसा बोलते हैं। तो प्लीज माय लॉर्डशिप सेंड इट फॉर वीएलसी वीसी क्रिएशन कॉम्प्रोमाइज लगा दो हम लोग करने
The matter again on Monday at 2:30.
May I make a request, Lord? Yeah, writ petition number 3148, which may kindly be connected with it.
प्लीज मैं हो जाएगा पूरा लड़की लोग मैं मर जाएगी करके भी बोलते, कौन उसका जिम्मेदार होता है? हमको कॉम्प्रोमाइज करने के लिए मीडिएशन के लिए रेफर कीजिए। मेनी केसेस सुप्रीम कोर्ट में मीडिएशन के लिए करता है।
matter, petition 2347 of 2022 on Karnataka matters.
May it please, my lord.
Just before my learned friend Mr. Kamath begins, yesterday your lordships were taking a list of the matters, IAs in support of the petitioner. I'm sorry I missed it out. I also have an IA number 13, and it's by a women's rights organization. Your lordships will make a note of it. Whenever your lordships permit, I'll argue in my turn.
You moved an application for intervener.
That's right, I'm an intervener supporting the petitioners, on multiple grounds.
Which writ petition you have moved?
Item number 1, in WP 2347.
All right.
Yes, grateful.
May it please, my lord.
Yes.
I filed an affidavit before in the morning, lordship. It also is the record, lordship. I just wanted to point out bring the fact before this honorable court. The order which is passed by this honorable court, it is grossly misused by the state lordship. But if kindly take the para number 11, the order, it clearly says that it is only respect of those colleges where college development committee has prescribed the uniform. In spite of that, they are imposing it to every institution's lordship. Muslim girls are forced to remove their hijabs. Even yesterday in Gulbarga, government officials went to Urdu schools. They forced students as well as the teachers.
Have you moved any application?
I have given an affidavit, lordship, in that aspect to.
Affidavit will not serve the purpose. You move an application for clarification. If you move an application for clarification, seeking some clarification of some order, then we can clarify that. In what context the order has been passed in.
Lordship, but the fact is that apart from misuse, the clarification, lordship, it's getting misused by the authorities, lordship. That facts I want to bring before this honorable court.
All right, you will direct the respondents.
And I have presented all the media reports, which has been today's media reports, and how it has been.
Direct the respondent to seek instructions on this.
Okay. I may only point out that there is no application. There is some memo. No, allow me to complete, sir. There is a memo, and it is a memorandum of facts is been sworn to by the council appearing in the matter, and there is no statements. Kindly peruse, it is as vague as it is permissible. Let them come up with a proper application and a proper prayer. We'll respond to that. We can't respond to such kind of vague allegations. And there is absolutely no affidavit by the party lords who has filed the petition.
I myself I cannot file application. I filed affidavit to state some facts of the matter.
Who has filed the affidavit?
I only have filed the affidavit, lordship. These are the facts.
No, that you cannot file an affidavit.
No, Lordship, I
are a lawyer.
am not moving any application. For that reason, I am not.
We don't think that a lawyer can file an affidavit
These
in
are
a case that would amount to misconduct.
My humble submission, Lordship. These kind of incidents are happening in society, which is affecting the.
Whatever, don't become a party to the litigation.
Court will look into it. Let's start. The court is in season of the matter. Court is aware of all these things. So let me proceed. Lord, sir, I was yesterday, my lord. Lord, if I can request the court master, I can't see the honorable court, my lord. The focus is on the my lord, the audience, the lawyers, my lord. I can't see. I'm grateful, my lord. My lords, first of all, my lord, your lordships have, lord, had the pain, my lords, of hearing me for over, my lords, 4-5 hours. And I'll be very brief, my lord. I will try to sum up, my lord, my balance arguments. But a couple of queries.
Our experience is that one lawyer in one case.
Yes, yes, my lord. Yes, yes. My lords,
we will
a couple of queries.
One lawyer to argue the matter.
Yes, my lord. My lord, yesterday a couple of important questions had fallen from the honorable court. And my lord, I was on the question of public order. And my lord, an important observation which was made by this honorable court is, why are you emphasizing on public order? The state has not said so. And in that connection, my lord, I had brought the attention of this honorable court to the last portion of the GO, which talks about, my lord, Sarvajanika Suvyavasthe. And according to us, my lord, this is public order. No, there is some disturbance. If others can mute their mics, please. The court may get disturbed. So, my lord, the state objected.
Give the government order. Copy of government order.
The Kannada word which is used, my lord, is Sarvajanika Suvyavasthe. And the state says, my lord, that this is capable of more than one meaning, if I have understood the learned AG right. And it does not mean.
Yes.
And it does not mean public order. That was the argument which was made. And the learned AG said, my lord, that the interpretation, the translation was not correct, etc. So, my lord, I had to go to the official translation of the Constitution of India in Kannada, which is released by the Government of India. And if I can just place that for the benefit of this honorable court, Shahul, can you just hand it over to the court master, please? And my lord, lordships will see that all the articles in the Constitution which use the word public order, the Kannada translation is Sarvajanika Suvyavasthe. It is as clear as day, my lord. I am really surprised that the state even, my lord, took up this argument that this is capable of more than one meaning. But I'm really surprised. Either they have not opened the Constitution or they have not bothered to see the translation. Either of these two, my lord. Just have a look at, my lord. Yes, my lord.
Mr. Kamath.
Yes, my lord.
We are interpreting an order made by the government.
Yes, my lord.
We are not interpreting the terms employed in a legislation, much less a constitutional document. The settled legal position is where certain terms are employed in the government orders. We cannot interpret them on par with the terms employed in statutory instruments, legislations. This is how law is structured. Therefore, we cannot, just because these two words are used, we cannot equate them with entry 1, list 2 of 7th schedule was my answer to you.
May I respond to that, Lord? Lords, I respectfully submit that the word Sarvajanika Suvyavasthe, which has been used in the order, GO, my lord, is not capable of two meanings. That's my first submission. It's up to your lordships, my lord, to accept it or not.
That's right.
It is as clear as day, my lord. It is not a Narova, Kunjarova, my lord's doctrine. ये भी हो सकता है, वो भी हो सकता है. It's not that case, my lord. Because public order as per the constitution in Kannada is Sarvajanika Suvyavasthe. And my lords, if the government thinks that the words which it employs can have a different connotation, can have a different meaning than what is assigned in the constitution, I am sorry, my lords, that is the interpretation which, my lord, which does not flow from any, my lord's, constitutional doctrine. What is there in the constitution is public order Sarvajanika Suvyavasthe. And my lord, if the state has used that term in the GO, that has to be given the same meaning. So just, my lord, just to end this point, if your lordships have this Kannada constitution, lords, interestingly, I was just going through the word public order, my lord, in the constitution is used 9 times. And just for the lordship reference, lordships may not make a note of it. 19.2, 19.3, 19.4, 25.1, 26, 88B, 6th schedule item 15, 7th schedule list 2 item 1, and list 3 item 3. All places, my lord, uniform Kannada word which is used is Sarvajanika Suvyavasthe. Just one page, if your lordship see article 25, how it is interpreted, my lord. And just before that, my lord, it's very interesting why this document was made available in Kannada by the government of India. And it says, my lord, as a part of the, just have a look at the preface, my lord. You know, since we are students of constitutional law, lordships, yesterday, my lord, told me to get an authoritative translation, my lord. And my lord, I had an occasion to learn because of that. But for that question, my lord, I would not have had the benefit of actually, my lords, going through this. Just have a look at the preface, my lord. The present digital.
You have seen the judgment of Apex Court.
Yes,
Justice Honorable Justice Hikayatullah's comment.
Yes,
in Sajjan Singh's case.
Yes, my lord.
I don't want to play the role of a grammarian.
Yes, my lord. I vote on, my lord.
Such question arose.
Yes.
When such question arose, this was the comment of the Apex Court, the great
Correct.
judge of the Apex Court.
Correct, no, absolutely. My lords, just kindly have a look at paragraph 2. The present DigiLoad edition of the Constitution has been prepared by the Parliamentary Affairs Department, so and so, as a part of the implementation of the decision of the central government to make available the Constitution of India and central laws to the general public in their own regional official language to enable them to know the law of the land. And this is a guidance to the state as well, my lord. In its true spirit, to fulfill the constitutional mandate. Now, my lords, may kindly turn to page article 25, which your lordships will find. The English version is at page 13. Subject to public order. And the Kannada version is the next page, my lord. Sarvajanika Suvyavasthege ನೈತಿಕತೆಗೆ ಮತ್ತು ಆರೋಗ್ಯಕ್ಕೆ ಹಾಗೂ ಈ ಭಾಗದ ಇತರ ಉಪಬಂಧಗಳಿಗೆ ಒಳಪಟ್ಟು ಎಲ್ಲಾ ವ್ಯಕ್ತಿಗಳು ಅಂತಃಸಾಕ್ಷಿ ಸ್ವಾತಂತ್ರ್ಯಕ್ಕೆ ಸಮಾನ ರೀತಿಯಲ್ಲಿ ಹಕ್ಕು ಉಳ್ಳವರಾಗಿರುತ್ತಾರೆ ಹಾಗೂ ಅಬಾಧಿತವಾಗಿ ಧರ್ಮವನ್ನು ಅವಲಂಬಿಸುವುದಕ್ಕೆ ಆಚರಿಸುವುದಕ್ಕೆ ಮತ್ತು ಪ್ರಚಾರ ಮಾಡುವುದಕ್ಕೆ ಹಕ್ಕು ಉಳ್ಳವರಾಗಿರ್ತಾರೆ. So my lord, very categorically that Sarvajanika Suvyavastha is public order, and I rest my case with this, my lord, that the government order uses the term Sarvajanik Suvyavastha. It cannot have an interpretation other than what is there in the constitution. That's my first point. The second point, my lord, an important question which fell from the bench yesterday, and a very pertinent question, that why are you only going on article 25(1), and that question, my lord, fell from the honorable the Chief Justice. There is also 25(2), and 25(2) talks about reform, and whether that reform is can apply even to essential religious practice. My lord, that is answered by the Supreme Court in a Constitution bench decision in 1962 supplementary SCR, page 496. Lords, I'll just place, I'm not going to place the facts, but very interesting facts, my lord.
Name of the case.
Yes, 1962. It is 1962, 2 SCR 496, Sardar Sayedna Tahir Saifuddin versus state. But I'll just place the facts. Lord, this pertains to the Bohra community. And my lord, what had happened was that the Bombay legislature passed a law saying that the head of the community cannot excommunicate a member of that community on the ground that he had violated religious norms. So, my lord, a penal consequence was provided, which in the community law, which said that, look here, if you violate religious injunctions, you will be excommunicated from the community. So a law was brought in to prohibit that, to abolish that. And 32 petitions were filed, my lord. And the Supreme Court, my lord, said that if it is a part of essential practice, even this, my lord, was upheld. So kindly see, my lord, in that context, just a few pages, the opinion of the majority is, my lord, of Justice Das. And if I can just place para, my lords, page 553 of the report. Das and Iyengar are entering, and Justice Sinha is dissenting. And dissent is even more interesting. I'll just place that. I'll place the majority first. Para page 553 of the report.
553. Last but one page.
Yes, my lord.
Last but one page.
Yes, my lord. I'm grateful. I'm grateful. My lord, the second paragraph, in my view, the phrase laws providing for social welfare and reform, it was not intended to enable the legislature to reform a religion out of existence of identity. Article 25(2)(a), having provided for legislation dealing with economic, financial, political, or secular activity which may be associated with religious practices, the succeeding clause proceeds to deal with other activities of religious groups, and also these must also be those which are associated with religion. Just as the activities referred to in 25(2)(a) are obviously not of the essence of religion, similarly, saving in Article 25(2)(b) is not intended to cover the basic essentials of the creed of a religion which is protected by 25(1). So, my lord, if it is an essence of the religion, neither under, my lords, 25(2)(a) or (b), my lord, that can be, my lords, curtailed. Subject to, my lord, of course, public order, morality, and health. These are overriding considerations. And, my lords, what is public order? There is, my lord, the majority was struck down the law on the ground that it violates 25. The minority, my lord, Justice Sinha, upheld the law. But, my lord, what he says at page 519 is interesting, and that is probably the law, my lord. Even the minority says that what is the extent to which the state can interfere a religious practice on the ground of public order should be something, my lord, which is abhorrent, which by itself, my lord, would create a certain degree of disturbance in society. And that, my lord, lordships will find at page 519. Page 519, somewhere in the middle of the page.
Yes, SCRs are like that.
I'm sorry, my lord. My lord, the SCR, the problem is, my lord, there are no paragraphs and there are no placitums also, my lord. So it's a little difficult for us to assist your lordship, but somewhere in the middle of the page, I requested my friends not to take printouts because long judgment I had marked from the SCR, my lord, so I requested them to give a printout of this. copy of this.
Yes, SCR is the only authoritative.
Yes,
this is the only authoritative publication.
Yes, my lord, that's right, my lordship. We refer to SCC, my lord, as a matter of practice, but your lordships are right, my lord. SCR is the only authoritative publication. A person is not liable to answer the verity of his religious views, and he cannot be questioned as to his religious beliefs by the state or by any other person. Thus, though his religious beliefs are entirely his own and his freedom to hold those beliefs is absolute, he has not the absolute right to act in any way he pleased in exercise of his religious beliefs. He is guaranteed the right to practice and propagate his religion subject to limitations aforesaid. His right to practice his religion must also be subject to criminal laws of the country, validly passed with reference to actions which the legislature has declared to be of penal character. Laws made by a competent legislature in the interest of public order and like restricting religious practices would come within the regulating power of the state. For example, now kindly see, my lord, this is the guidance which the Honorable Supreme Court gives. For example, just see this, my lord, religious practices of sacrifice of human beings. Just see this, my lord, abhorrent. Or sacrifice of animals in a way deleterious to the well-being of the community at large. It is open to the state to intervene by legislation, to restrict or to regulate to the extent of completely stopping such deleterious practices. It must therefore be thought that the freedom of conscience is guaranteed to every individual so that he may hold any beliefs he likes. His actions in pursuance to those beliefs may be liable to restriction in the interest of the community at large as may be determined by common consent, that is to say, by a competent legislature. It was on humanitarian grounds and for the purpose of social reforms that so-called religious practices like immolating a widow at the fire of her deceased husband or of dedicating a virgin girl of tender years to a god to function as a devadasi or of ostracizing a person from all social contact and religious communion on account of having eaten forbidden food or taboo were stopped by legislation. So, my lord, there is some amount of guidance as to how, my lord, this power, my lord, of the state has to be exercised. Now, my lord, in this particular case, lordships will see what is in question is an innocuous practice. Lordships have seen, my lord, Article 25. And my lord, words used here are freedom of conscience and the right to protect, practice and propagate religion.
Yes.
Yes, not the two. What I was submitting is not what flows from this judgment, especially Justice Sinha's judgment, is this: that, my lord, the guidance to the state in stopping a religious practice is that it should be something which is abhorrent, which has a deleterious effect on society. Then the state, on the ground of public order, morality, or health, can stop it. Now, in this case, my lord, this is an innocuous practice of wearing a headscarf. And, my lord, the constitution consciously, our framers, my lord, had great foresight. Ambedkar, my lord, and all the others, luminaries, my lord, had great foresight. They used the term freedom of conscience, my lord. And this has a lot of depth, my lord. My lord, what it protects is an innocent practice of faith. It protects an innocent practice of faith, but not a display of religious jingoism. Kindly see this, and I make these submissions with the utmost of respect and humility at my command. The essence of Article 25 is it protects the practice of faith, but not a mere display of religious identity or jingoism. My lords, kindly see. My lords, when I was in school, my lord, and college, I used to wear, my lord, a rudraksha on my neck. My lords, it was not a case of displaying my religious identity. My lords, I wore it because I felt a certain degree of protection, a certain link, my lord, with my creator. Lordships, I have seen, my lord, so many lawyers, senior lawyers, judges, my lord, where, my lord, certain customary, my lord, religious namams or whatever, my lord. This is not, my lord, a display of religious identity. It is, my lord, a practice of faith. That is what is protected by Article 25. To counter that, my lord, somebody wears a shawl, he will have to show, my lord, that is it a display of religious identity alone, or is it something more? If it is sanctioned by Hinduism, my lord, by our Vedas, Upanishads, or our scriptures, your lordships are duty bound to protect it. If not, my lord, then Article 25 doesn't protect it. That's the submission, my lord, which I wanted to make. The last, my lord, submission on this point, which the query which fell from your lordships yesterday, is that there is a law. State argues there is a law. There is an Education Act. Education Act is there. And under the Education Act, there is a 133 power. 133 power, they have made a order, and there is one earlier circular. And therefore, we have a law. And that law can curb the religious freedom. Not is it the way we are going to interpret Article 25? When the Article 25 says, my lord, that a law can be enacted to curb a religious practice on the ground of social reform, the law must explicitly, my lord, show that intent. Does the Education Act show that intent? It cannot be my understanding, my lord, or the state's understanding by way of an affidavit that by way of the Education Act, we can curb anybody's religious freedom. The legislature ought to have applied its mind, and that application of mind should be demonstrated by a provision of the Act itself or a statement of object and reasons. Otherwise, my lord, it's a very dangerous proposition, which the state is saying there is some act, Education Act, and we will rely upon it to curb somebody's freedom, relying upon the Article 25 2b, which says that we will make provision for social reform. The legislation itself, my lord, has to demonstrate ex facie that the legislation has an intent to reform, which is not the case, which can't be the case. And they can't explain it in an affidavit.
Education Act is not under challenge before us.
No, my lords, it is not. That's what I am saying. And the submission is this, that the Education Act, by any stretch of imagination, my lord, there is not even one iota of contemporaneous evidence to show either from the assembly debates or from the statement of object and reasons that this is a law which has been enacted for the purposes of curbing, my lord, hijab, or for that matter, my lord, stopping a religious practice. There has to be a specific intent. That is not there, my lord. So that's, my lord, the 3 points, my lord, 2 points which fell from the court, which I thought I had a duty to answer. Lord, the other, my lords, point which the Honorable Court asked me yesterday, that are there any other jurisdictions apart from, my lords, Muslim countries, my lords, which have gone into this aspect of hijab and how they have treated it with, my lord, constitutional rights? And that I thought, my lord, was a very, very pertinent question, and we did some homework, my lord. And I will cite one or two cases, and it is actually fascinating, my lord, because lordships, when I was arguing before the learned single judge, my lord, Justice Dikshit, he cited a very, my lord, interesting shloka of the Rigveda. He says, Ano Bhadra Krutvo Yantu Vishwataha, that let noble thoughts come from all directions. So, my lord, I will just take your lordships to a few of these countries which have similar, my lord, constitutional paradigm. And I will show, my lord, how religious rights, when compared with, my lord, competing rights, like rights of the school to maintain discipline, uniform, how, my lord, sports have responded to that. My lords, the first judgment I want to cite is a judgment from the South African High Court. That is, my lord, Anthony versus governing body. It's a matter of headscarf, my lord. If I can just ask my instructing counsel to just hand over. Anthony versus governing body. That is, my lord, 2004 essay 738. Anthony versus governing body. Lords, principles are quite, the facts are quite similar. Lords, here the applicant.
Two things you have to say.
Yes,
is it a theocratic state?
No,
Does
Lord,
it have a written constitution?
Yes, written constitution.
You have to analyze that.
Yes, my lord. I will just, I'll place that also. That's a very important question, my lord. The jurisdictions which I'm going to cite, my lord, are not theocratic states. These are states, my lord, which are bound by a written constitution, except for England. But South Africa, my lord, I will show how their rights regime is similar to ours. But in the next judgment, this is the High Court and I'll cite the Supreme Court. My lord, this is the case, paragraph 3. Paragraph 3 of the judgment, my lord. What is the issue?
Name of the
fact.
Mr. Kamath, please read name of the case because so many friends are here. They should hear what you say apart from us.
I'm sorry, my lord. I'm so sorry, my lord. I beg your lordship's apology. Anthony versus governing body, Settlers High School and others, 2002, 4 essay 738. And it is a judgment by Justice Van Zyl. And the facts are not noted in paragraph 3. The salient facts and circumstances